Chair.
Thank you, thank you. All right, Senator Gabriela Morris, you there?
Yes, Minister, I'm here. Morning.
I'll ask you to just say prayer for us before we get into our discussions. Thank you.
All right. Let's pray. Dear kind and Heavenly Father, as we meet this morning to discuss the business of the nation and to advance plans for the sexual harassment bill, I pray that you will guide us in all our deliberations, give us wisdom and understanding. And I pray that in the end, dear Lord, this bill will be in the interest of all Jamaican people. Continue to guide us as a country and bless us today and forevermore. In your name I pray, amen.
Thank you, Senator. Thank you so much. Ms. McCarthy, do we have any apologies for absence?
Good morning, Minister. No, we don't have any apologies.
All right, good. Thank you so much. So, colleagues, I just wish to make brief remarks before we commence. And let me start out by saying that our sustained efforts in this committee have brought us to where we are today, which is being able to consider our draft report. What we have been able to accomplish is to be credited to the diligence of your committee members, the steady guidance of our technical team, the dutiful committee clerk, Hansard writers, IT team, and the Houses of Parliament staff. At our last sitting, we completed the general recommendations made and began fine-tuning critical areas. Today, we continue that process for the purpose of completing our report. I wish to remind you that our work in this committee continues to be carried live on PBCJ, on cable, and online, and I ask that you have your cameras on whenever you're making your contributions. So without further delay, let us dive right into the work that we have to do. Now, we have outstanding decisions, members, that we have to now address before we go to our report, our draft report. I am just checking to see if our Solicitor General, you're here. I don't know if you are ready to.
Yes, Chair.
Okay.
And the AGC team is present.
Okay, fantastic. SG, I don't know if you're ready to give us your comments on 39.2, which you are going to do some research and get back to us on. Clause 39.2 in relation to offense of making false complaints.
Yes, thank you, Chair. I did further research and haven't been able to find any other similar provision. And just to point out, the provision that was discussed from the Protected Disclosures Act, I don't think is quite on point, but I think that the committee will know, having heard all the discussion, I think it's just to take a decision as to whether you want to keep the current construct of the fine and have it be a default custodial sentence, or you want to have a fine or imprisonment, and also the nature of the fine. Or I had also proposed earlier having a fine and in default of payment, a sanction under the Criminal Justice Reform Act, which would be, I would have suggested community service. So I think those are the options that you would have before the committee to discuss.
Thank you, SG. I see Senator Natalie Campbell-Rodriguez. Could you go ahead and make your comment?
Good morning, Minister. Good morning, colleagues. Please ignore the background. My daughter left it here. I'll take it down in a minute. Just to say, SG, that we had also asked for an opinion on using the word knowingly, or I forget now what were some of the other options between the not and the make. I think that was one of the things we discussed, sticking a word in there which leads to the idea that the person is not purposely trying to create mischief, even though it may be deemed that the complaint is not accurate. I'm trying to choose my words carefully, which is never a good thing for me, but yes.
Yes, thank you, Senator. I had actually offered an opinion on this earlier, which is that when I think you had initially made that suggestion, it was knowing, and of all the words, I would have used knowingly because that is a construct that it's not so much precedent, but there's judicial interpretation on it. So I would prefer using knowingly. Whereas I didn't have an objection to the insertion of the word knowingly, I think it was Minister Johnson Smith who had indicated that she wasn't sure that it was completely necessary or useful in this type of provision where it's the person you have made this false complaint. You made the complaint. You would know whether or not it was false. And I think she questioned the utility of inserting the word knowingly. It's hard to tell you anything else because, as I say, I can't find a provision that is on point with this. The other provisions that I found had knowingly, but they're different. So let me explain the difference with, like, say, the Protected Disclosure Act. So under this law, what this provision is doing is saying if the person made a false complaint, it's an offense. And it says a false complaint because under this act, you can make a complaint. So if it was a false complaint, that's the offense. Under the Protected Disclosures Act, protected disclosures can be made. The act does not criminalize making a false protected disclosure. What it criminalizes is making a false statement in the proceedings. So if you make a statement which you would have sworn to and submitted at any stage in the proceedings and it's false, that is what is criminalized. So it's not quite the same. And then the word knowingly is used in that context. Generally, where you have provisions that talk about the making of false statements or false declarations, you will see the word knowingly in it. But as I said, it's not necessarily on all fours. But again, I don't have a legal concern with using the word knowingly, but I know that others had raised some concerns about it. I'm sorry that I can't offer any more guidance on the matter.
Thank you. Thank you.
Thank you, SG. Thank you, Senator Campbell Rodriguez. Senator Gale, would you wish to comment here?
Good morning, Chair. Good morning, colleagues. So when you look at the clause, the fact that false complaint already qualifies it as being false, the insertion of knowingly just further amplifies the extent of it where the person would have been fully aware that they were making a false complaint. So in terms of dealing with 39.1, the insertion of knowingly just put a greater emphasis on the false complaint. Where I think we should focus is, having said that, where I think we should focus is where in 2, a person who contravenes subsection 1 commits an offense and shall on summary conviction in a parish court be liable to a fine not exceeding $1 million or in default of payment thereof. So we first speak about the fine not exceeding the amount. And so, Jen, you can remind us whether or not we would have moved away from having the conviction with the payment, or is there's a separation where we deal with the conviction and default of payment to include the imprisonment. I think we'd have been moving away from having the two together and having a separation.
Oh, okay, so thank you for that query. Through you, Chair. Let me, in a nutshell, just give you an idea of the scheme that Parliament has been utilizing more recently. So, some time ago, years ago, the construct for penalties used to be fine or imprisonment or both. More recently, and I remember a quite lively discussion in the chamber in which you sit, Senator, with the JACRA law, where there was a big discussion about why fine, imprisonment, or both as a routine. And the discussion was to separate it. So you would have fine or imprisonment. You wouldn't have both if there was no pecuniary advantage that could attach to the offender. So you would then, so meaning the only time you would want to direct the court to consider imposing a fine and a custodial sentence is where you thought that there was some pecuniary advantage that could attach. Then also the Parliament has now also been moving towards, instead of having a custodial element, that you look at other modes of punishment for several reasons. One, the overcrowding in the prisons, and two, to highlight other modalities such as community service and electronic monitoring of offenders and that sort of thing. So in a lot of instances, you would see a fine, and only if there's default of payment would you see that custodial sentence. And in a few, you will actually see that there is no custodial sentence and you use one of the other modes that are reflected in the Criminal Justice Reform Act. What I would like to say, though, I noticed a scheme in this bill, and let's not dwell on the fact that the penalties for everything were the same. But the scheme to me that I think is important is that it wasn't a fine or imprisonment for anything. It was a fine, and in default of payment of the fine, then there would have been consideration for the custodial sentence. I say that because I do agree with some of the comments that were raised before about 39. That offense in 39 is actually a very serious offense, taking into account the nature of the subject matter and what it can do to persons. And of course, it is true that there are other options. You have the Defamation Act, you have common law offenses such as creating public mischief and all of that. But to be honest, it is a serious offense. And the thing is, even with this serious offense, again, what was proposed was a fine, and in default of payment of fine, the a custodial sentence. So again, you have to look at the scheme in this particular legislation, and I think it was done in this way because of the nature of this particular piece of legislation.
Thank you, SG. I see Senator Fraser-Binns' hand up. Could you go ahead, Senator?
Thank you, Minister. Good morning, colleagues. Morning, Minister. I want to just make a contribution on 39.1, and it has to come off what Senator Rodriguez was talking about in terms of knowingly. And I wondered, and I will seek some guidance as well, because I am minded to agree that the insertion of knowingly really helps the provision. I say that because, and again, when one looks at the fine, one can make a false complaint against someone, really not knowing that the complaint is false, but genuinely believing that the complaint is correct, and only later discover that the complaint is false. You compare that to someone who knowingly, who deliberately, who intentionally makes a false complaint against another person. And when one considers those two scenarios, I believe that the insertion of the word knowingly further qualifies the offense of making a false statement. And I'd be happy for that to be inserted because, as I said, it does add to it. Instead, and then of course, what it does is, considering the fine, it increases the burden. So if you knowingly, deliberately says something that is false, then you pay $1 million. But if you make a false statement, not knowing it to be false, then I don't believe that the same penalty should apply. Thank you, Minister.
Thank you, Senator Benz. I will recognize MP Angela Brown-Burke and then Senator Longmore.
Thank you very much. Thank you very much, Minister. Like others, I too am concerned, but well, I agree that with Section 39, that knowingly making a false complaint is something to be taken seriously. And it has to be taken seriously, just given the repercussions, of all of that. I also am aware that in our society, there are individuals who might actually just do it knowing that it is false. My concern, of course, is how we differentiate between someone knowingly making a false complaint and someone making a complaint which the tribunal or others might find that the burden of proof of the case has not been made. And what I would not want is for us not to be able to distinguish those two, and for individuals not to step forward because they are afraid that 39 might apply, even though they do feel that they have a proper case. Those will be my concern.
Thank you, MP Brown-Burke. Senator Longmore.
Agreement with the insertion of knowingly. I recognize MP Brown-Burke's concern in terms of maybe the hesitation for persons to make the complaint. But I think we go back to the PR that is necessary to go along with this bill, but we must have the protection against the tendency to abuse the provisions of the bill. So my vote is for it to be inserted. Thank you, Chair.
Thank you, Senator Longmore. In this case, knowingly means intentionally, deliberately making a false complaint. SG, can you sort of?
Chair, your volume is a bit low. I don't know if I'm the one who's having the issue.
No, I don't know. Sometimes my
Thank you.
Instrument here. But can you hear me any better?
A bit better, Chair. Thank you.
Yeah. SG, did you hear?
Yes, yes, and you're correct. You're correct, Chair. You're correct.
Yes.
It was intentional, deliberate. You knew what you're doing, and there was the intent of doing it.
All right. So members, maybe at this point we can make a decision if we insert knowingly. I don't think the technical team would have a major problem if we do so, although we heard what the SG said. So I always like to call on Senator Gale.
Agreed.
Okay, as a start, other members, we will insert knowingly.
Yes, Minister, agreed.
Agreed.
Okay, and our technical team, you do not have a problem with that. Ms. Grant?
No, Chair, I'm fine.
You're fine, so noted, okay. All right, now we need to settle on 39.2. Are we going with it as is? $1 million, or in default of payment, imprisonment, not exceeding 3 months, or community service, whichever. I would like a comments on 39.2 and a decision. Go ahead, Senator Campbell Rodriguez.
Thank you, Minister. Just to say that given that we have inserted the word knowingly, I am comfortable with part 2, because I had raised adding in knowingly or some other word there in order to keep 2 in place. So I am personally comfortable.
Thank you. Members, we agree? So say all of us?
Agreed, Minister.
All right.
Minister, just I chipped out for a minute. So I'm begging your
Please go
just
ahead.
yes. I just wanted to know whether or not the matter that I raised is clear, and I have no reason to worry about someone who brought a case where the burden of proof has not been met, and the difference between that and a false complaint.
I think it is clear, but I would ask Ms. Grant or the SG to just clarify that for you.
Thank you.
Yeah. SG, will you take it?
I'm sorry, I'm not clear. Is it that you're, member, that you're saying that the person would have made a complaint which they know is not false? But if there could be repercussions from that?
Yes, I guess my concern really would just be whether or not, as we have it now, there would be clarity around a complaint that is well meant, that is made, where the tribunal might find that there is not enough burden of proof provided to substantiate the complaint, but that it could not, by virtue of that, once a person did not, because the person did not knowingly make a false complaint, that they could not be subject to 39. I just wanted to know that how it is set out, that I would have no need to worry.
Oh, okay. But the issue is whether it's false or not. So once the person is not telling a lie, then it doesn't matter whether they gave incomplete information, because incomplete information to me is a lot different than information that is false.
Right.
So once the information is not false, then they wouldn't have any issue. Anybody making a complaint that is not false would not have any reason to fear from this provision. What you're not to do is make a complaint that is false.
Okay.
And that is when then the provision could be activated by a court. You could be prosecuted.
Okay. All right. Thank you very much for that clarification.
All right. Thank you, MP, and thank you, SG. All right. Now, definition of sexual harassment. The JCTU suggested that the committee remove all traces of reasonable and reasonableness from the definition of sexual harassment. Committee agreed that the term reasonable should be removed, as well as term unreasonably in part B of the definition of sexual harassment. We need to make a decision on this. So if we could just look at the definition and make a decision in this regard. Ms.
I don't know how she used to do it. Okay.
Yes, Chair.
Yes, just want to expand on that so we can make a final decision. Yes, please.
Not a problem, Chair. Just to say that it had come up in previous meetings, members, where this was discussed, but based on my notes and certainly discussions with the committee clerk, we don't have where a decision was in fact made. There was strong support for the most part for it, but it was not decided on.
So Chair, can
Yes.
the strong support overrule or override and influence a decision? What I recall was the use of the word unreasonably to have been taken out. Was that correct, Ms. Grant?
Yes, Senator, there was strong
Right.
support for
What
that.
I wouldn't want us to do is to go back over these discussions when it is no longer fresh in our mind. But there was a time when we just never made a decision, but the discussion was so overwhelmingly swinging the
In a
pendulum
direction.
in a direction. And so we could use that to make a determination.
So it is important that we make a decision at this point.
I'm in
Aye.
favor in what the committee had decided or
Aye.
discussed. Right, Angela?
Yeah, absolutely. Absolutely. And I remember this discussion well,
Yes.
that there was in fact an overwhelming discussion around support for
yes.
removing that idea of unreasonableness, especially because it is the individual, the victim, who determine what is unwelcome sexual advance.
All right. So the decision is, as agreed at that time, that the term reasonable should be removed, as well as the term unreasonably in Part B of the definition of sexual harassment.
Aye.
So say all of us. All right, in clause 3, now we're really now getting, we're fine tuning everything at this point. Clause 3, duty to ensure environment free of sexual harassment. Section 3 refers to the duty of the employer to ensure environment free of sexual harassment. The committee indicated at that time the use of the term reasonable effort needed to be decided on. Reasonable effort needed to be decided on. Do we agree? The use of the term reasonable effort to be decided on. Ms. Grant, please go ahead.
Yes, Chair. I remember this discussion, like MP Brownberg, very well myself. And I do recall that it was an issue that was raised by an entity. And I do recall, I believe the SG saying in relation to this, that reasonable would be just as it is there in the bill, what is reasonable according to the Westbury rules of reasonableness. And so even though the particular entity was saying, oh, we should define what reasonable effort means, what I do recall is that the committee didn't particularly agree to define it, but there were a lot of this, well, there was no decision as to what was to be done with it. Some people said it didn't need definition. Some didn't say anything. I'm of the view, Chair, that it doesn't need to be defined. It speaks for itself.
Chair, may I'm a little, you see, it is going to be very difficult to qualify what constitutes a reasonable effort. In this case, whilst we're seeking to...
Hello? Hello? Sorry, is this clause 3?
Yes, clause 3.
It is clause 3.
Clause 3, Soldier.
Section 3.
And the term reasonable effort. Whilst we're not in any way is going to prevent the occurrence from happening. What we have to ensure is that the measures in treating with it are important. So reasonable effort, can mean that you educate your employees that around this thing. And that it is not something that is acceptable within the organization. And where the statement or the policy, that's a reasonable effort. That can be constituted as a reasonable effort. But once we start qualifying reasonable effort, we're going to run into problems. So I would leave it.
Ms. Grant, I see your hand up.
I'm sorry, Chair, it was to come down.
Okay, MP Brownberg. Thank you.
Sure, thank you. I'm also assuming that reasonableness in this regard would also relate to whatever policies or code that the institution has in terms of, Senator Gale is correct, the policies and the public education of that part is one, is a beginning. And then within the policy would be how some of the complaints are to be treated and the procedures and so on. And therefore reasonable effort in this regard would also be guided by the process and procedures that have been set out and whether or not those have been followed as well. Am I correct?
Yes. Okay, so the decision is that we will not. Ms. Grant, what is the clear understanding you have based on all the discussions here? I got a little distracted. Thank you, MP Bromberg.
That it needs not be defined, Chair.
Okay, good. Thank you. Agreed? So
Agreed, Chair.
Aye.
Aye.
The matter of student-to-student harassment. Committee noted that harassment in institutions can be student-to-student. Committee indicated that the bill should address harassment between students in institutions. And the committee to decide was to decide if the bill is to have applicability from the age of consent, that is from age 16 and above, or from the age of majority, that is from 18 years. I will ask Ms. Grant or the SG to just explain again for the benefit of the committee, the implications there, and for us to make a decision.
SG, do you wish to take this or should I?
Yes, okay, go ahead.
Yes, Minister. I was asking the Sultan if she wished to take it or should I? But
Well, you notice, so far the
Yes,
SG is not blocked.
Yes,
SG,
Ms.
are you
Grant,
going to
but
take it?
no, Ms. Grant is very capable of handling chair, so.
all right, Minister, just as a refresher for the committee, this discussion, remember, it was first placed on the table when the committee, yes, Senator Gale, expressed strong support when agreed that they felt that matters dealing with children needed to carry some punitive kind of sanction. And the committee agreed that the appropriate acts would not be this particular legislation. And the comment was made, I'm not sure which member made it, but I recall the comment being made that we would need to, I think Senator Longmore really began the flow of this discussion, that we would need to decide then if, since this legislation will not be applicable to children anymore, we would need to decide if it is to apply then from the age of consent upward, or if it would apply at the age of majority, given institutions, how it would function in colleges, universities, etc. Would we go from 16 up or 18 and above?
So members, we have to make the decision, and I think it should be from the age of majority, that is from 18.
Minister,
Yes.
if I may, I would go along with 18 as well.
Okay, so say all of us.
Minister, I heard I heard what Ms. Grant said, and I am tempted to go along with you. I just would want, just for further clarity and understanding as to exactly why we would want to start at 18 as against starting at 16.
Okay, Ms. Grant, could you, and then I'll take Senator Binns.
What was said, Member Brownberg, was that suggestion was made. Someone suggested starting from 16, and the comment was made that as it is with a lot of our legislations, it rarely starts from the age of majority, 18 and over. And if we're saying that even though you have attained the age of consent at 16, you are, for all intents and purposes, still a child. And so the committee, my understanding certainly at the time, was that it would be more fittingly applied to 18 and above.
Which would mean that there's no lacuna in terms of covering those individuals between 16 and 18. There's been no gap. I mean,
well, it certainly would not be addressed under this legislation.
Which is fine as long as it's addressed elsewhere. That's kind of what I was saying. Okay. Well, thank you.
Be addressed elsewhere.
Right.
Senator Fraser-Binns.
Thank you, Minister. Two quick contributions I want to make. One is I will go with the majority, but I do believe that if we are saying in law that a child can consent to sexual intercourse at the age of 16 years, then I am unsure why we are saying that the child can't consent otherwise. We recently concluded the amendments to the Sexual Offences Act, and the issue of the age of consent featured very prominently. And the decision was taken that the age of consent should remain at 16 and not increase to 18 years old. And in my mind, this discussion again brings to the fore the inconsistency with which we treat with children, whether they are 16 years old for the purpose of being able to consent, or 18 years old for the purpose of being able to vote or to get married. And you know, Minister, I believe that it may not be the place here for it, but what we have to do is to really take a serious decision as to what age are we going to say is the acceptable age for these things, because there is an inconsistency in my mind that we're agreeing that a child can consent to sexual intercourse at age 16, but the child can't consent to, and I'm using the term loosely, consent here, can't agree or that, let me not put that way. We're saying that a child can consent to sexual intercourse at age 16, but until the child is 18, the issue of consent regarding sexual harassment is not a live issue. And I think there's just an inconsistency in my mind. And it seems to me that the majority is going with the age of 18, and I'm fine with that. But I believe we need to seriously look at that issue of age once and for all across the board, so that there is no doubt that a child goes until the age of 18, and at the age of 18, you can consent to every and anything, depending on it. You can consent to every and anything, but as it is now, the different age groups in my mind is just an inconsistency. The second thing, and it's more of a technical question, I wondered whether there is a need, I don't recall it being said, but I wonder whether there is a need for us to state expressly in this legislation that it will not be applicable to children, because there isn't anything presently that speaks to that. And I don't recall there being a proposal for that provision to be made. So I will be guided by the technical team on the second point.
Thank you, Senator Fraser-Binns. I would like to invite a member of the technical team to respond to that. I don't know who will take that one. SG. Ms. Grant?
Sorry, yes, Minister, Chair, not sure how to respond, because you see, consent is not a feature at all in this law because it's unwelcome. So there, yeah, but I understand the point.
If I may, Minister.
Understand the point. Okay.
Sergeant, sorry to interrupt, but I'm not seeking a response to the issue of consent and the age. I'm just making a point that we have to, at some point in the very near future, make a determination about age, because there is an inconsistency as relates to the age for children. So I'm not seeking a comment on that issue. I'm giving my own observation on the need for us to address the issue of age. The issue on which I'm seeking a comment is on whether there should be an express provision relative to the fact that this legislation does not deal with children.
Okay, so I was getting around to that because I was going to say that, Senator Fraser-Binns, that I do understand the concern you have with the age issue, especially as I was part of those discussions in another place for another related piece of legislation. So I do take the point. I think the bigger issue, I guess, is that in some pieces of legislation, we just refer to the age because once you say a child, it doesn't apply to a child. And because we know under the Child Care and Protection Act, a child is any person under 18, that we end up just relying on that definition, and insufficient consideration is given to the other related issue that a person 16 and over can give consent. So you're correct that there is that inconsistency. As it relates to the bill indicating clearly that it should not, it does not apply to children. I actually had a note to say on my bill that that decision was taken on the 24th of March, and that it would remove children from the remit of this bill. And I agree that I think it would need to be clearly stated that children are not, this bill does not apply to children, but I guess I could be guided on that issue, but I think it would be good to have a clear statement on that in the bill.
Right. So SG, thank you so much. That will be so stated in the report.
Minister, I was assured earlier that for persons between the ages of 16 and 18, that the matter of sexual harassment would have been dealt with otherwise. Just for my own edification, what would be the bill that would cover that? Where would that matter be dealt with if it's not dealt with this one?
SG?
I did not make that comment, so I really can't answer that question. I don't know.
Ms. Grant? Thank you, SG.
Yes, Minister. I recall the committee indicating that how such an issue would be treated with is that in the report, it would be the suggestion would be made that the Sexual Offences Act as well as the Child Care and Protection Act, that those two acts would be so amended to address instances of sexual harassment where children are involved. So that is what I meant by that, Member Bromberg.
Okay, so that should be done.
So
which means that
in this report, we would be recommending such amendment to those two pieces of legislation.
Okay.
And that will be captured in the report. All
Um,
right.
Chair,
Yes,
if I could be permitted just to raise for consideration, and I'm sorry that I am now prolonging the discussion, but
no,
a team member has raised
important.
what I actually think is a very valuable point. Mrs. Masada has said this bill is dealing with institutions, like say a university. We do have 17-year-olds at our university. And again, taking into account this whole discussion that 17-year-old can consent, that 17-year-old can legally consent, can be married, and can be at an institution. And we're saying that 17-year-old can't be afforded the protection under this law. So again, from that perspective, I don't know. I have to tell you, I'm not a policymaker, but I do see some merit in having it applied to persons who are 16 and over. I really do see that. And I mean, it legally it can be done, because you can define child for the purposes of this law to mean anyone under 16. You can do that. We have done it in other pieces of legislation. But to be honest, it's really a policy decision. And I think a matter that the committee should really carefully consider, taking into account the scheme of this law and taking into account some of the points raised by other members earlier, including some good points raised by Senator Fraser Binns about the age of the child and all of that.
SG, I think we should take your guidance, and I think the committee members hear you loud and clear, and that we should give serious consideration and make the decision that provision should be made to cover those between the ages of 16 to 18 as well.
And if I may just be permitted to just quote unquote big up my team member, Mrs. Masado, for raising this thoughtful issue. Yes.
And that is why the technical team is so critical in this these deliberations. We depend very much on your guidance so that nothing falls between the cracks.
Absolutely.
So thank you so much. Thank you so much. I know Senator Gale has been anxious to make a comment. I recognize
thank you, Chair. And it's just the fact that this aspect of the legislation has now found further focus by what was being represented by Senator Fraser Binns and the input from both the SG and Mrs. Masado. Like a cricketer, you get a ball that you cannot leave alone.
Yes.
And I believe that we ought not to leave it alone as a gap, because if reviewing this legislation as I identified it so much, then we must find a way to fix it rather than just leave it to an instruction from the report that elsewhere fix it. When we have the opportunity to fix what can be fixed right now. And I would want to encourage that approach. If we can fix it, let us see if we can fix it.
Excellent. I really want to commend the committee members and the technical team. We are being very thorough. And I think this is really excellent. Excellent example. Senator Longmore, I recognize you. Please put your...
Thank you, Chair. I just wanted, I listened in and such. I just wanted to underscore my initial passion about this issue. And I'm very glad to see the energy that is being expressed at this time. Thank you.
Thank you so much. I'm going to ask Mrs. Robinson from the Bureau, because this impacts on the policy, for her to just make a comment.
Thank you, Madam Chair. So yes, I do agree that provision should be made for persons 16 years and over in institutions. because I recall when we were having the conversations for the Sexual Offences Act and the Child Care Protection Act, there was nothing definitive in terms of how we deal with persons in that age group. So I do believe if it is done here, then when it continues in terms of finalizing those two pieces of legislation, we would have already set the precedents here. And it would put to rest the questions and the comments and the queries that persons have about the group and which group. We don't want to leave any group out. This bill should be covering all areas and all groups, and nobody is left behind.
Good. Thank you, Mrs. Robinson. Thank you.
You're welcome, Minister.
All right, so decision taken. So say all of us. I can
Aye.
now move on to
Aye.
clause 6. Duty of person in charge of an institution to take action to deal with sexual harassment. Section 6 addresses the duty of person in charge of an institution to take action to deal with sexual harassment. The committee noted the proposal to add a section that allowed for the possibility of the complainant to proceed to the tribunal if the complainant is aggrieved by the immediate or appropriate action that the employer or institution might have taken under subsection 1. Committee indicated that the complainant could make a submission to the tribunal, state the reason for being aggrieved, and present evidence to substantiate the claim. I'm going to ask Ms. Grant to just expand on this so it's very clear to our members in relation to clause 6 and to see if this is covered anywhere else. Ms. Grant, please.
Yes, Chair. So as you rightly said, as to what section 6 addresses, the duty of the person in charge of an institution to take action to deal with sexual harassment. The concern that was raised here is that a person in charge of an institution could take immediate and appropriate action, but it is not sufficient and the complainant is aggrieved by the conduct. And it was raised that in such a case, the complainant should be able to bring a claim to the tribunal, indicating that yes, regardless of the fact that this action was taken immediate and appropriate, I am not satisfied with it, and these are the reasons why I'm dissatisfied with what was done, and I'm asking the tribunal to rule on it. It was a very live issue when it was first brought up, but there was no concrete decision as to how it should be treated, if it should be inserted at all, or if it was just good food for thought.
Thank you, Ms. Grant. Senator Gale, go ahead.
So Chair, I can connect easily with this request. And I take it from the standpoint of a grievance at the workplace that would not have been resolved at the local level, despite the fact that it would have gone through the scrutiny at the local level, but there's no agreement. And so the provisions in law gives it the opportunity to escalate that grievance through the Ministry of Labor, and if there's no agreement, through the tribunal. Now, in this case, it is likely that a complaint will be raised that would go through the mechanism of the procedures within the workplace or institution, and the complainant is still so aggrieved. And so what is being asked here is for some provisions to be made where the matter can be escalated, because the employer may very well be satisfied in their mind that they have done all that would have been required or appropriate. But the individual or the complainant would be so still aggrieved. And so do we make provisions in this legislation to allow for that escalation? And that's his question that is being asked. And I would humbly submit that if we can, then let us do so.
Thank you, Senator Gale. Mr. Seeley Brown, please go ahead.
Thank you, Chair. Could I just turn our attention to clause 25 and subclause 4, please, to see if that addresses the concerns that have been raised? Because whereas in clause 25.3, it speaks of exhaustive use of your internal mechanisms and procedures, you may still be granted leave by the commissioner if you don't think that those circumstances provided in subsection 5 has, I mean, that you're not satisfied with whatever the outcome is at the internal level, and you satisfy the circumstances on the clause, subclause 5, you have that option from what I'm reading, Chair. So you don't necessarily have to go through your internal mechanisms if you can prove what is set out in subsection, subclause 5. You said you reasonably believe, Chair, that your rights have been prejudiced if you were to comply, or that there are no internal mechanisms or adequate internal mechanisms that have been made available to you. You can directly go to the tribunal. So I'm just wondering if we should consider that and see if we need to tweak it, or if that is not sufficient to deal with the concern that was being raised.
Can I just clarify something in this case?
Yes, go ahead, Senator.
Mrs. Seeley Brown, is it a situation, does it capture that situation where the complainant is still not satisfied, and so they would escalate it to the tribunal, having gone through the internal process?
Mr. Seeley Brown?
I'm looking at B, Chair.
B of
subclause 5.
That's 25.5B.
Yeah.
Provided evidence to show that no...
Because that speaks more to the availability of an internal mechanism. And not necessarily that you are not satisfied.
Right.
Yeah, but we open up another issue for discussion as to what would be deemed to have been satisfactory in a particular claim. Because I'm not sure how are you going to determine whether or not I don't know.
You see, what the bill does.
That's in legislation, yeah.
What the bill does is that the bill allows the determination of satisfaction at the level of the tribunal. That's what it does. So the internal mechanism is the trigger that takes it to the tribunal, and not to settle it at the local level. It was never meant to settle it at the local level.
So we can probably, sorry, Senator, so we may probably be able to say then that you may apply for leave if you think that you have not been given the appropriate remedy.
Right.
Something like if you're not satisfied, so then you would have to now make that application to the tribunal.
To the tribunal.
Yeah, that prima facie case as to
right.
whether or not they think that the remedy was adequate, and then grant you leave to move on to the tribunal. I'm hearing before the tribunal.
And I'm looking at it against the background that in all instances, we would seek to arrive at an agreement before the imposition of an award or judgment. So allow the internal mechanism to be able to resolve the issue, and not that every matter that has been raised or identified is triggered to a tribunal.
Yeah. So Chair, what we could say, we could probably put in words in subclause 5 to say where the complainant feels that his complaint was not adequately addressed, and then so that will not trigger an automatic hearing, but grant you leave So the tribunal would listen to the reasons why you think this may not have been adequately addressed. And then if it is satisfied, because that's the whole issue of leave, it grants you leave to further have for them to further have a hearing. So I understand that, Chair.
Oh, okay, very good.
That's the decision of the committee, though. That's,
I see the hands coming up, so I'll take down mine.
Okay, thank you, Senator Gale. Thank you, Mrs. Celia Brown. I hope Ms. Grant and Ms. McCarthy, you captured that. I know other contributions are coming fast and furiously. I will recognize Solicitor General, then Senator Fraser-Binns.
Thank you, Chair. I'm not sure that the proposal by Mrs. Celia Brown is necessary, because the bill already contemplates that if you're not happy with how something has been addressed, you do get that opportunity to approach a tribunal. It's just that you should try to exhaust your internal mechanisms first. So that's all 3 is doing. It's just saying, which is a similar procedure to go to a court, or, well, when you're making an appeal and all of that. It's just saying, yes, you can go, and you would only really go if you're not happy, if your issue has not been addressed. So you would go, but you must exhaust your internal mechanisms. However, if you haven't exhausted your internal mechanisms, then 5 trips in, and 5 says, despite the fact that you didn't do all of that, you could still approach. But it's not that if you're not happy, you wouldn't be able to approach. That's not my interpretation of 25, going through from 1 to 3, 4 and 5. I'm not sure that it's necessary at all, because if you then make the change to 5, I think you would then have to make another change to 3, to 25.3, because I think it's already accommodated. So I don't know. My own review, I'm not sure. I'm not clear on what is then being proposed.
Chair, may I just come back in to just ask Mali, sorry, SG. When I look at 5, the 2 circumstances are very specific. So you will only be granted leave if you show that your rights may have been prejudiced if you were to comply with 3. Right, so it is implying here that you can't use. There's no way you could have used the internal mechanism. In this case, I think, correct me if I'm mistaken, is that they would have used that internal mechanism, but they are not satisfied with the outcome. No, Senator Gale and Chair, was that the concern, that they have used this internal mechanism, but they're not satisfied with the outcome? That's why I was saying you will have to amend subclause 5 to put in something else. And as you quite rightly say, you will have to look at how you exclude it from subclause 3, because subclause 5 hinges on subclause 3 to say that if your complaint was adequately addressed, you may seek leave to go to the tribunal, notwithstanding what is said in subclause 3 and subclause 5. Because I think subclause 5 implies that you would have gone to this internal mechanism, and for some reason you're not satisfied, or there is no internal mechanism procedure, so that's why you're coming. But it doesn't deal with the case where you've been through this whole internal mechanism process and you're still not satisfied that your rights were adequately, your complaint was adequately addressed. So I agree with you, it's a little different. That's why I said you're going to have to tweak subclause 5, or even include a subclause 6 to say, notwithstanding what is there, where you have used up the internal mechanism procedure and you're not satisfied that your rights have been adequately addressed, then you can ask the tribunal for leave, make an application for leave to have your matter being heard before the tribunal. I hope I explained it clearer.
Thank you, Mrs. Celia Brown. I'm going to recognize Senator Fraser-Binns and then Mrs. Simon from Legal Reform.
Minister, I can actually lower my hand because my concern has been addressed through the correspondence between the Solicitor General and Mrs. Celia Brown.
Okay, thank you. Mrs. Simon, please go ahead.
I was just going to say that I agree with the Solicitor General. I do think that
We lost you.
has to be satisfied or not. It's just that you must exhaust the mechanisms first. Sorry? Oh, you lost me. So
Yes,
sorry
can you
about
repeat?
that.
Repeat.
My internet connection is unstable. I will pause the video. I was saying that I agree with the Solicitor General that just the scenarios that were raised, it doesn't require that you must be satisfied or dissatisfied. It just says you must exhaust them first. I think having exhausted them and you are dissatisfied, then you are able to make a complaint.
Okay. No.
I don't know if you heard that. Sorry, Chair.
I heard that. Yes, I heard you. Thank you. Mrs. Celia Brown, would you want to make further comments?
What I said, Chair, it doesn't cover, I think, the concern that was raised that you have used up all of this internal, the mechanisms, the procedures that are available, and you still are not satisfied that your complaint was adequately addressed. And in my humble view, I don't think that 3 and 5 deals with that, because 5 subclause 5 follows on from 3, which says that you must exhaust the internal mechanism, and it's only then, only if you're sure that your rights have been prejudiced or that there were no internal mechanisms, may you apply for leave. So I think if you want to address that concern of you had a hearing and you weren't satisfied, you may have to include another provision saying, notwithstanding what is in 3 and 5, you may still be granted leave if you can show to the tribunal that you exhausted all these internal procedures and mechanisms, and you still don't think that your rights were adequately addressed.
Thank you, Mrs. Celia Brown. So the committee, I would say that it won't do any harm to include that. What members, what do you think, members?
Let me explain what I'm trying to arrive at, Chair.
Yes.
When I look at, so in 3, it says exhaust the use of any internal mechanism and procedures that are available. So you cannot go to the tribunal without going through that process. That is clearly understood. Now, in 5, it says the circumstances referred to in subsection 4 are that the tribunal is satisfied that the person has as a shown cause as to why the person reasonably believes that the person's right may be prejudiced if the person were to comply with subsection 3. So the term there to qualify is the person's right may be prejudiced. And in B, it shows and demonstrates that it provides evidence to show that no internal mechanism and procedures or no adequate internal mechanism and procedures have been made available. So that is quite clear in my mind. There's absolutely no mechanism. So you jump to the tribunal. But ANO only suggests, in my mind, that there has to be a prejudice to the rights of the individual for you to qualify to appear before the tribunal. So you would have utilized your internal mechanism, you know. No. But there is no agreement whatsoever. You're not satisfied with the outcome utilizing the procedure that you would have exhausted. And so there has to be a catalyst that allows you to be able to qualify to appear before the tribunal, or for the matter to be escalated to the tribunal that is not contained in either 5A or B. And what I'm asking is that could it be an expansion of 5A or 5B for a C to be included that further qualifies your ability to appear before the tribunal?
Chair, may I just to clarify one thing you said, Senator Gale. Also in 5A, you are not going before you're not using your internal mechanisms because you reasonably believe that your right to be prejudiced if you were to comply. So in both of these cases, you're not using that mechanism at all. So you're coming straight to the tribunal because you believe if you use that mechanism, your right may be prejudiced or there are no internal mechanisms. What we're trying to remedy here is where you have used those internal mechanisms and
Right.
don't think that it has been fair.
Right.
So
It has been what?
It has been fair. It has been fair.
Right.
So you're now asking for leave from the tribunal to come before them with your matter. But in 5A and B, 5A, you don't want to use the internal mechanisms at all because you feel that so there's no hearing pursuant to subclause 3. And in the other case in B, there is just no internal mechanism at all. You understand?
I understand that.
Right. So there's no, in both cases, 3, you're not using 3. But what I think they want to address is where you have used 3 and you're not satisfied.
And you're not satisfied.
Yes.
There's no agreement.
Yes.
So the
Yes.
tribunal now becomes the arbiter.
Yes, yes. That's how that's it. I think that is the concern.
That's my concern. That's exactly my concern.
Yes, yes.
So,
let's see what the SG has to say.
Yes. So let me take the SG, after which I will take Senator Fraser-Binns. Go ahead, SG.
Thanks, Chair. Sorry to make light of something, but despite the Vinci accent, I understand what you're saying, Mrs. Seeley Brown. I think you needed to spell a word for Senator Gale, but I understand the point, and I understand the point now, and I agree that there is a lacuna. So I don't think, subject to what Senator Fraser-Binns says as well, I don't think you would need to prolong the discussion. I agree that you could address the point. You could, if the committee agrees, I think you could try to address that lacuna, which I think was unintentional.
Yes. Thank you, SG. Thank you, Mr. Seeley Brown. Senator Fraser-Binns, please.
Thank you, Minister. Mine is more for clarification from Senator Gale. Senator Gale, I haven't heard you. I get the impression that what you are seeking to do is to have the tribunal be more like an appeal tribunal in that instance. Is that correct? So the person who, the victim, not happy with the outcome of the use of the internal processes, would then appeal to the tribunal. Is that what you're seeking?
So I would love to have seen the expression on your face when you're asking me that question. And you see, what I'm pointing out, Senator Fraser-Binns, is a situation where it is likely to happen, where the internal mechanism, notwithstanding it being there, the complainant might not be satisfied with the outcome. And the internal mechanism must not be seen as a cap. There must be, if there's failure to arrive at an agreement or an understanding or the fair treatment of the situation, then the right to escalate it to be heard before the tribunal is a provision. Whether you want to treat it as being an appellate body, that's fine.
May I again, Chair? Sorry to be interrupted.
Go ahead.
Yeah. So, Chair, where I think it should possibly that to allay the concerns that are being raised by Mrs. Fraser-Binns, maybe we should put that insertion in clause 25, so it becomes one of the grounds for making a complaint. So we add a D. What do you think? I would like to hear the views of the members of the technical team.
Add a D where?
That you
Add a D where?
In clause 25, which speaks of making of a complaint.
Oh, okay. So A, B, C, and D.
Yes, it doesn't. So you don't look at it as an appeal. So you've gone to the tribunal and you don't think that your rights were adequately addressed. Then that should be one of your grounds of making a complaint.
Thank you, Mrs. Celia Brown. I'm going to take the SG and then Mrs. Simon.
Thank you, Chair. Thank you. I really should have allowed Senator Fraser Binns to go ahead of me.
No,
Because
she did ask, she sought some clarification.
no. What I mean is because my comments would have been tailored a little bit because I did think through something else, which was if this, what I now call a lacuna, is not addressed in the bill, the remedy for the person would be to approach the court, which they can, as a judicial review matter. And I do recall discussions regarding the policy, which was we didn't want to force persons to have to go to court to address matters that could be addressed at, let me use the words more local level. Local, not just meaning within your own institution, whether workplace, educational, or accommodation, but also before this tribunal. So I think it would be in keeping with the policy to address this situation by allowing that person to also have the tribunal hear that matter, because otherwise their only other remedy would be to approach the court by way of a judicial review claim, which I think is not consistent with the policy.
Chair, Mrs. Aldred, thanks for that, Marlene. She's quite right. Because you remember to Mrs. Aldred, when it was drafted the first time, there were also some complaints that were going directly to the court, remember? And some that were going to the tribunal. And I think that is how the lacuna probably arose. So we can address it in the manner that we're discussing now, Chair.
Right. Thank you, Mrs. Celia Brown. I recognize Ms. Grant.
Yes, Chair. I was just looking at it in light of what Mrs. Celia Brown suggested to insert a D at 25. And I agree with this, Chair. I think it would be a cleaner insertion too, to just insert the D at 25, and that would take care of the concerns being raised.
All right, thank you, Ms. Grant. Senator Fraser Binns, you have your hand up. You wanted to make a comment?
Yes, Minister. Thanks for that, Mrs. Aldred. I wonder though, and I am in favor of that insertion, but I wondered, Senator Gale, whether for clarity that the, want for a better term, appeal to the tribunal, whether it should be a wide open appeal or whether the grounds should be stated. In other words, if the matter goes through the internal process and a determination is made that the accused was in fact guilty, using the term loosely guilty, and a determination made pursuant to that, if the victim is not satisfied, whether because she would have wanted a different outcome, though the person has been found guilty, but should have wanted a different outcome, whether because she wants some kind of monetary compensation or she wanted the person to lose his job, whatever it is that he or she may want, but that which he or she desires was not done. Are we going to allow the person to appeal to the tribunal for every and any reason, or is there going to be a specific basis upon which that person can appeal to the tribunal? I'm just seeking clarity because, yeah, I'm not clear in my mind if there's going to be any kind of containment or if it's going to be carte blanche.
So you're quite right in distilling the discussion that way. What we have is that we have in 34 the remedies of a tribunal award in 34, and that's the only way area in the legislation that qualifies an outcome. So there's nothing that suggests using the internal mechanism that displays what possible solutions are. It's not contained in the bill. And so what the internal mechanism does not make the provision for a conclusion, a possible conclusion at the local level. So what would trigger going to the tribunal? And so what it is left to is for an agreement to take place at the local level using the internal mechanism. But we leave ourselves open that no agreement may be reached. So it might say, the complainant might say, I want compensation, but the compensation is not enough, right? What triggers it at that stage to go to another level? Yes. And that is where the 25D may possibly come in. But then having discussed it further, it opens up our eyes where you have indicated that there must be some qualified trigger to expressively escalate it to the level of the tribunal. What is happening here in our chair is that the more we discuss this, yes, the more we're going to be open to filling the gap.
Yes.
And that it goes to both houses of parliament, there may not be any amendment needed.
Excellent work. Excellent work of this committee. I'm going to recognize Mrs. Simon and then Mrs. Seeley Brown and then Mrs. McCarthy. Please go ahead, Mrs.
Simon. Yes, Chair. I was just noting regarding the query Mrs. Seeley Brown had mentioned regarding where the clause should be inserted. I was just looking at how 25(1) is worded, and it starts with that chapeau, a person who alleges that. So based on that chapeau, I'm not sure that it would fit well there as a D, and that it might actually fit what initially suggested in 5. So the tribunal leave, notwithstanding that the person has exhausted the mechanisms, and because the chapeau suggests an allegation, and this is just simply a case where the person has gone through the internal mechanisms and is dissatisfied. So I'm not sure it fits there.
Okay. Thank you, Mrs. Simon. Mrs. Seeley Brown?
Chair, I don't know if I would have this discussion now because I'm going to have to look at it again, but I don't think the alleging at the top would hurt anything, because you're going to be alleging that your rights have not been adequately addressed before a tribunal. So I don't see, and I don't think it would interfere with what we have in 25(1) either, but that's a technical drafting issue. And even if we think that it can't go there, we can put it somewhere else. So I mean, because I'm even thinking back to thinking about what was said earlier by Mrs. Fraser-Baines, as when you talk about what are the circumstances which may require you to make this this application before the tribunal. And I'm thinking that maybe one way you may want to leave before you actually have that hearing. So those are issues that we can look at and see how we can address it once the policy decision is taken, that you want to have that lacuna filled in the legislation.
Thank you, Mrs. Seeley Brown. I will recognize the SG, and then I will go to Mrs. McCarthy.
Thank you, Chair. I'm sorry, sometimes I'm delayed because I can't find the mouse.
That's okay.
Sorry about that. I agree with Mrs. Seeley Brown. I think what's important is just to get the decision of the committee, and then the technical team can work with Mrs. Seeley Brown to ensure that the direction of the committee is adequately addressed and drafted in the bill. So, for instance, if there's a clarification or clarity given to indicate what the committee wants in terms of this issue, then we'll get it done. And I don't think, I would just ask that you not ask for the actual wording and drafting to be done right now because of how the scheme is set out right now in 25. It will need some amount of tweaking. And it's just a matter of just making sure that we understand the directive and direction of the committee. I think that's all that's really important right now.
Chair, can I just say
With
something?
respect, sorry.
Yeah.
Senator Gale, if I could just hear from Mrs. McCarthy.
Yes.
She had her hand up for quite a while. Go ahead.
Sorry. I just wanted to get clarity as to because we started on section 6 and Senator Gale came in with the proposal. So I'm just wanting to clarify that the committee, whether or not the committee has agreed to accept the proposal at 6 that would allow for the change at 25 or not. Just for the sake of the report.
Well, that's a decision we are about to make.
Okay.
Chair, sorry.
Yes?
Sorry, but isn't the decision at 25 wider than just a decision at 6? I'm seeking clarity.
No reason for being agreed on, President, is it right? It says our proposal to add a section that allowed for the possibility of the complainant to proceed to the tribunal if the complainant is aggrieved by the immediate or appropriate action that the employer institution might have taken.
Sits wider.
Right?
Sits wider. It will have to include, Chair, all of the, everything that these, it will have to include 7, whatever happens at 7, sexual harassment at the workplace, it will have to take into consideration that, won't it? 8 and 7 and 8. Why are we limiting it to 6? That speaks to at an institution. That's just my, I'm confused as to why we're limiting it to 6.
I'm sorry, Chair, if I could give some context. It arose initially under 6, Mrs. Seeley Brown. That's why it came up there.
Yes.
But it will be wider. We agree that it will be wider than 6, Chair.
I just want to explain that what I'm going through the notes, clause by clause, where decisions were not taken.
Okay.
All right?
Yes, Chair. Thank you.
Yes.
Chair, I just want to say this, because I understand and appreciate the work of the technical team. And I also understand that the technical team is already overburdened. And I don't want to place any undue burden further on the technical team. But the fact that we would have been identifying these issues here, what we may have to do is make a note of them through the report, and certainly by the time it gets to both houses of parliament, we are in a position to make the necessary amendments and not detain ourselves today or for any immediate meeting after this for the wording and how it's scripted to be taken. So I'm suggesting that to the committee, if that approach can be accepted. I'm a trade unionist. I want to be as reasonable as possible to those who have to work.
Senator Gale.
Yes, Chair.
We always agree on everything. On this occasion, I only agree partially with you. We have to make decisions. We can't put off things.
Now, I was not suggesting to put it off, you know. It's how it's dealt with.
Yes, I think we have gotten to a point where we can give guidance to the technical team. And they will take it from there. And I think what they're asking for right now from the committee is guidance.
Fine.
Am I right, SG? Or Ms. Grant? Yes, SG.
Sorry, Minister, I missed the last part of what
what you're asking right now is for guidance in relation to to the matters that we have been discussing as to what the decision is of the committee, and then the technical team will address how it's worded and come back to us on that.
Okay. So I think the committee should then be considering whether, as it relates to, I think it would be 6, 7, 8, and 9. If a person who has gone through internal mechanisms but is still aggrieved by the decision arising out of the internal mechanism, whether that person can still approach the tribunal for a final decision. And if the committee agrees with that.
Yeah, in essence, that is what Senator Gale has put forward.
Yes, Chair.
That's right. Thank you, SG. Ms. Grant, you wanted to add a comment to that?
No, Chair.
Right, so it is clear what we are asking members. So SG and the technical team will look at that and come back to us. Right, SG?
Yes, and it would really just be if it's agreed, it would just go in the report. So Mrs. McCarthy could note it for the draft report, which she circulated last night. And also it would be for Mrs. Seeley Brown to just reflect it in the draft amendment.
That is correct. That is correct. Thank you, SG. Thank you, members. So now we move on now. In relation to the keeping of accurate records. Committee noted the observation that there is no immediate requirement for the employer or person in charge of an institution to ensure that accurate and complete records are maintained and retained in keeping with legal requirements. Committee noted a proposal to add a subsection that reads, and I quote, all involved in dealing with alleged sexual harassment should be aware that any notes that are made or documents that are created could be requested by the tribunal as part of further investigation, and individuals could be called to give evidence. All efforts should be made to ensure that written records are clear, accurate, and appropriate. The committee accepted the recommendation for keeping of records, but agreed that it should be a stand-alone section which created a duty for the keeping of records, the particulars of the records, and how long records will be kept, the duty of confidentiality, among other things. In furtherance, the committee asked for the technical team to do research to see if any similar provisions existed in other jurisdictions. And so I see SG.
I will defer to Ms. Grant, if anything,
Yeah,
right
Ms.
now,
Grant?
Chair.
Yes, could you please? Yes.
Yes, Chair. I did some research of my own. I have not found in the 6 pieces of legislation that I have gone through any mention of any keeping of accurate records. So it would seem to appear that we would be first out the gate in this regard. So it would be, I do recall the committee really agreeing that this should go in. We were just asked to look if there was anything in any other jurisdiction. I don't know if any of my other colleagues found anything, but I didn't.
All right, I see Mrs. Seeley Brown. Thank you, Ms. Grant.
Thank you, Chair. And Ms. Grant is correct. And I think it's for 2 reasons why we haven't seen it. One of the reasons is that in some cases, sexual harassment is a criminal offense. The second reason, which is where we're out first, is the fact that we are expecting this whole internal mechanism and this policy to be developed, and for this internal mechanism to be utilized before you get to the tribunal. So I think it is necessary for us to put in a provision that speaks to keeping of adequate records and deal with the confidentiality aspect, and even create a criminal offense around where you may have breached that confidentiality in regard to those records. So I think it's something that the committee can consider for insertion.
Okay, excellent. So all members agree that we will include that provision? Agreed?
Agreed.
Thank you.
Agreed.
So much. Thank you, thank you. We go on to clause 10, where we were looking at designation of authorized officers. Clause 10 authorizes the minister to designate certain field officers in the Bureau of Gender Affairs as authorized officers to act as investigators of complaints. Committee took note of the proposal to include rules to guide these authorized officers, as well as to inform the complainants and alleged harassers of their roles. Some of these rules need to be addressed. For example, the confidentiality of the investigation, the responsibility to interview both the complainant and the alleged harasser, presenting an alleged harasser with a written document containing details of the complaint against him or her, separately interviewing all witnesses, taking appropriate notes and written statements, collecting and reviewing all documents concerned, and preparing a written report for the tribunal. Now, the committee did not reach any decision on whether this should be included in the legislation, and we would need to make a decision on these matters. I don't know if Ms. Grant wants to expand on this, and then for us to decide. Go ahead, Ms. Grant.
No, Chair, I think what you have said there was quite clear.
Right. I don't know if what I've stated here, if you all captured and recall, you want me to go through it one more time? I think.
Minister, I would appreciate if you could go through one more time.
Okay, and this is clause 10. Clause 10.
Yes, clause 10.
Yes, clause 10 authorizes the minister to designate certain field officers in the Bureau of Gender Affairs as authorized officers, quote, unquote, to act as investigators of complaints. Committee took note of the proposal to include rules to guide these authorized officers, as well as to inform the complainants and alleged harassers of their roles. Some of these rules need to be addressed, and I outlined them. A, the confidentiality of the investigation. B, the responsibility to interview both the complainant and the alleged harasser. C, presenting an alleged harasser with a written document containing details of the complaint against him or her. D, separately interviewing all witnesses. E, taking appropriate notes and written statements. F, collecting and reviewing all documents concerned. And G, preparing a written report for the tribunal. Committee has to reach a decision on whether this should be included in the legislation. Mrs. Celia Brown, I see your hand. I recognize you.
Thank you, Chair. And I'm thinking that this, while I see the importance of A, I'm thinking that B was put in at another place before the policy was changed, because I'm thinking there is no mechanism now in the draft, in the bill, for a complaint to get to the minister with responsibility for gender affairs. So I'm just wondering, how is this mechanism going to be triggered of the minister having authorized officers investigate that complaint? And everything that you highlighted in what you read, Chair, to me would be now the responsibility of the tribunal. And I don't know if the SG would correct me if I'm wrong. I'm thinking that this may have been there when the policy was that everything would have been going to a court. So I could see where you were the importance of having the minister sending out field officers in relation to matters on the clause 3 and 4, which is that you're making reasonable efforts so that you have you have an environment that is free of sexual harassment, and the fact that you're actually implementing this sexual harassment policy, which will now form part of this act as a schedule. So that will be the responsibility of the minister with responsibility for gender affairs. But I'm not seeing from the draft as it is now, how is it that how a complaint, how big would be triggered? How would you as minister with responsibility for gender affairs know that you need to investigate a complaint when you have established a tribunal? And like I'm saying, I think this was left when the policy was at another place where there were mechanisms before going to the court. I stand corrected, Chair.
Okay. I'm going to Senator Gale. I want to just go to Mrs. Robinson.
That's fine.
Ask her to respond to Mrs. Seeley Brown's query.
Okay, thank you, Madam Chair. So I've listened to Mrs. Seeley Brown concerns about the designation of the authorized officers. And I wanted to share here that the reason, in terms of my recollection, the reasons we had the introduction of designated officers, authorized officers, is to allow for fair representation of the complaints itself, to allow for the persons who are lodging complaints to have an ability or an opportunity to express what it is, because prior to now, all the cases would go to court. That is under the earlier iteration of this bill. It would go straight to court. We had, as was pointed out in an earlier meeting, we had asked the Ministry of Labor and Social Security, based on what the first part of the bill had said earlier on, that we would have a special division of the IDT treat with the cases, but that was not going to happen. So the idea was to have a go-between, a provision that would allow for the complainants to have an ability to express their views and to make the case plain. This would be taken by these authorized officers, and those reports would be crafted and fed to the tribunal for them to investigate. Now, in terms of the certification of designation, we had conversations with the Ministry of Labor and Social Security about how it would work, given the fact that this is where it would reside initially, in the Ministry of Labor and Social Security. And we were advised that the positions in terms of authorized officer were very similar to the labor officers. And labor officers would have had an instrument that would allow them to collect the information and to do the reports and to get the information in place and so on. So if it is that we're going to have authorized officers, then it would be similar, and the certificate of designation would not be unorthodox, because what it would allow is to have something or a mechanism that allows them to have relevance and credibility. It would now be to decide how we establish that provision or that mechanism that allows for the certification to be in place, but it is not unorthodox. And it would allow for the complainant to feel as if they are now in a space that is non-discriminatory and would allow them to express whatever the case is, everything to be very blatantly, brutally open, and just to, because in some cases there are nuances that some persons really don't want to express. And so even the categories of persons who would take the cases, the qualification is that those persons would have some amount of training in social work and be able, so like social workers who have dealt with persons in this space, so they will listen without forming judgments, and the persons will be comfortable making their complaints and giving their statements, because the burden of proof is there in terms of the person who has brought this complaint. And so you want to make sure that whatever is taken by this authorized officer is comprehensive enough that the members of the tribunal will have evidence to work with, so they can actually make a fair, in terms of judgment or decision, whatever it is that is going to come out once they get the reports.
I don't think though this has answered the question that Mrs. Celia Brown was asking as to the Bureau comes in, is that the tribunal, the Secretariat operates out of the Bureau of Gender Affairs and the, Mrs. Celia Brown, could you go ahead and.
Thank you, Chair. No, Chair, I have no issues with subclause 2 or even clause 10 in its as it's written. What I'm saying, and I think it was highlighted somewhat in the responses, that because at that time we had the court as the final arbiter, and I think in some cases you were going to the disputes tribunal, it was necessary to have somehow the complaints, there was a mechanism for the ministry to be involved in the investigating of a complaint. You now have the tribunal, so the ministry doesn't become involved in investigating. There's nothing in this act that triggers any complaint going through the ministry. So I think clause B, paragraph B of subclause 1 of 10 needs to go. If what you're saying is that you may have the expertise with respect to social workers to deal with that sort of thing, it will have to be done by the tribunal, because the tribunal is the body now who the complaint is made against, and they will have in their rules and procedures that they may need to hire, whether it's a social worker or whoever, to advise them as to the nature of a complaint. That's a different thing. But what I'm saying, there's no mechanism in this bill to trigger subclause 1B anymore, because we don't have that situation where you had to go to the court and there was this internal mechanism in the former legislation where the ministry got involved. That's all I'm saying. So 10 is fine as it stands if we exclude, but we need to look at taking out B, because B has no place now in this new scheme as drafted. So the issues with respect to certification of designation and all of that, Chair, that's fine. I'm just saying that there's no mechanism where B is triggered in the legislation now. Thanks, Chair.
Thank you, Mrs. Celia Brown. I'm going to take Senator Gale and then Ms. Grant.
Chair, I just want to see clarity on something. Maybe it would have been dealt with before, but it's just that I can't remember this morning if it was dealt with. So 5 and 6 deals with the internal mechanism as both the workplace and the institution. But what triggers the complaint of the accommodation, and how does that get to the tribunal? Where is that mechanism? Did we treat with it anywhere? Because that is where I'm now seeing the possibility of utilizing 10 to assist with that. If it's not dealt with anywhere, I can't recall us establishing a mechanism in treating with those under the accommodation.
All right, Senator Gill, I'm going to ask Ms. Grant to respond to that, and I think she may have had another clarification. Or
Yes, Chair. All right, so Senator Gill, I take the point that you just made, and I'm looking on the bill, and I'm based on the construct of the bill, the accommodations have no internal mechanisms. They would go directly to the tribunal. So they would fit under, because clause 13 gives the tribunal the jurisdiction to hear it where a complaint is made by a person in relation to any matter arising under section 9. And so they would go directly to the tribunal, and when they go, then they would have to go under 25(5)(b) to show that, okay, listen, there are no internal mechanisms available, so I am coming directly to you. So there are no internal mechanisms as exist for the workplace and the institutions. So the accommodations, those in accommodations would go straight to the tribunal.
All right, thank you for satisfying that concern.
Totally correct, Chair, and that is why
I appreciate it.
Yeah, and that's why we say, Chair, that 10(5), because 10(1)(b), because it's coming from another place. When you had a different scheme in the legislation, it needs to be taken out. So they can investigate. So what the ministry will become is like a regulator. ensuring that the compliance of the employer with respect to internal mechanisms and all that. That's fine, but they can't investigate a complaint under this scheme.
All
So
right.
that needs to be debated.
So my next question then, the functions that you express, Chair, that detail listing, will that be inserted somewhere in the legislation?
Chair, may I respond?
Yes.
Please.
Respect, no, Senator Gill, because those what Chair would have read out would have been functions that would be conducted by the tribunal.
Yes.
Okay.
Yeah.
Okay.
The investigating of a complaint. Remember, they will have their own. Remember, we have already said in the legislation that they will have their own mechanisms for rules and procedures. So those will be taken care of there. So there's no need to put that in the legislation. Once we out paragraph B.
So these are field officers who would be operating on behalf of the tribunal, authorized officers.
So where will those functions reside in terms of record?
The Secretariat.
The Secretariat.
Yes.
Okay.
But Chair, through you. Sorry, said it again. Sorry.
It is just, all right. So these are authorized officers so defined in the legislation. And so, you know, when a police comes to investigate, there's nobody questioning the police or the authority of the police. And in this case, when these authorized officers come to investigate or do anything, it's just for the transparency of it, that it resides somewhere that someone can check the authority of it. It's not going to be contained in the legislations as you have indicated, but I just want to be satisfied that it resides somewhere so that there is no question about their roles and function. The comparison that is used in terms of the labor officers at the Ministry of Labor, I believe the Labor Officers Act expressively outlines the roles and functions and the authority of these individuals. So I just want to be satisfied that in the pursuance of their duties as authorized officers, that they are going to be so designated, there is record somewhere that if it requires anybody to check, there's no question about it.
Chair, may I just again, Chair? Senator Gill, remember also that their functions, if we agree that we're going to be removing paragraph B, their functions will be as it relates to clause 3 and 4. So if you look at clause 3 and 4, the duty to ensure that the employer has an environment that is free of sexual harassment, and with you instituting your policy statement. If you look at 4, so that is what the authorized officer will be checking and regulating. Nothing to do with complaints.
Go ahead, Ms. Grant.
I was just thinking, Chair, that Mrs. Seeley Brown, bear with me. So if we remove 10B, because based on what Mrs. Seeley Brown said, there is no longer any need for the authorized officers to investigate because the reference to the court has been taken out. So they would go straight to the tribunal. I'm thinking that the complaint. So the authorized officers would no longer need to investigate, right?
Let me stop you there, Ms. Grant. I'm not there. If they can investigate, but they're not going to be investigating a specific complaint. So they can investigate, for instance, the fact that an employer has not had in place a sexual harassment policy as is under clause 4.
Okay.
Or they can investigate the fact that he doesn't have an environment that is free. He has not made reasonable effort to ensure that his place of employment is free of sexual harassment. So they still have to have those duties. But what I'm saying, what the functions that were read out by Chair, correct me if I'm incorrect, deals specifically with the investigation of complaints relating to sexual harassment. And I'm saying that those complaints would not be dealt with in this manner by a designated authorized officer. If it's a case where the tribunal may want to draw on the experience of an authorized officer because that officer is a social worker or a psychiatrist or a psychologist. Remember, under their rules, they can always ask for that sort of assistance. So I don't think we need to put that particular type of assistance or function in this particular provision. But when it comes to them ensuring compliance with 3 and 4, if you want to craft, as Senator Gale was saying, to declare different functions as to how they enter premises, how they question, those functions that we put sometimes in the duty of an authorized officer to enter premises at a particular time, to ask for records and that sort of thing, to ensure that clause 3 and 4 is being complied with, that's fine. But we have to limit it to that and not anything dealing with that sexual harassment complaint pursuant to clause 10. That's all.
Right. So that I understand. But then I'm thinking in instances like a 9, where you don't have internal mechanisms and you have to go straight to the tribunal, that the tribunal would need some sort of legwork, so to speak, to be done before. So of course the complaint would have to be documented and so on and so forth. So
they would form resource.
So that's fine. That's fine, Ms. Grant, but it can't be on the 10. That's what I'm saying.
Right. So what I'm looking at, if 24 would, though it would not specifically state it, but it certainly would give them jurisdiction to pull on other resources. 24D.
Most definitely. Most definitely. And look at how Y24.1 is drafted also.
Yes.
Yeah, definitely. That's what I'm saying. And in their rules and procedures, they will determine how then they would now seek that type of expertise. You are totally correct. But it can't be that we leave it on the 10 with the current scheme, 10B, with the current scheme that we have. So you are absolutely correct.
I just want to be ensure, Chair, that they are designated authorized officers. Nobody would question their function if they were to turn up to a workplace. It is clear, based on the scope of the legislation, what they are required to do, and that it is functional, that nobody seeks to make them redundant later on.
Thank you, Senator Gale. Mrs. Simon? SG. I recognize you then, Mrs. Simon.
Thank you much. Thank you very much, Chair. My point was a little different. Just to respond to something Senator Gale had questioned about the functions of these field officers, these designated persons who are field officers. As far as I understand it, they are public officers. So public officers all have JDs, they all have their job descriptions, their functions already. So as public officers, they already have some amount of authority. And then the bill goes further to indicate their scope of work, even under this law, which is that they are to investigate and secure observance of sections 3 and 4 of the bill. And then you go further to see that they are to be provided with a certificate of designation. They are to produce that certificate. And if there is non-compliance by another person, it's actually a criminal offense. But I agree with Mrs. Seeley Brown that I think what is missing is that we should, as we do with any other sort of authorized officer who is securing compliance with a law, we give them specific powers to enter premises because that is a constitutional issue. So if we're allowing them to enter premises, which they will need to be able to do, we should give them that power. And that's a usual provision that Mrs. Seeley Brown can find in another law that she has drafted already that has been approved by both houses of parliament, just to allow them to enter premises. Usually we'll say at reasonable hours, to carry out their inspection, and similar provisions.
Thank you, SG. Mrs. Simon and then Mrs. Seeley Brown.
It was just to ask a query. with how that, with the deletion of 10B would fit with clause 27, where it says that the tribunal can cause an investigation, 27.1 can cause an investigation to be conducted into a complaint by the authorized officer. I'm just wondering, would it affect that?
No, because no, Chair, because the complaint would be in relation to paragraph A. B is not supposed to be there. There's nothing that triggers any complaint by the ministry in relation to a sexual harassment complaint. It doesn't affect it at all. And in relation to what Mrs. Aldrich said, Chair, there are numerous drafts that I've done and that the office has done, where we have inserted powers of authorized officers that we can draw on and insert in these provisions to provide for the right of the officers to enter and to ask questions, to look at documents and that type of thing. So that once it's agreed by the committee, those can be inserted, Chair.
Thank you.
Chair, just one comment though. I think we would have to tweak the language in 27, Mrs. Celia Brown, not to use the word complaint as it relates to the authorized officer. It wouldn't be a complaint per se by the authorized officer.
That was what I was asking about.
Right, I understand. Yes,
Okay.
I understand, Miss Simon.
Which clause is that? Which clause is that, Mrs.
27.1. Right near the end, it says into the complaint by the authorized officer. It wouldn't be a complaint. It would be the report or finding of the investigation or whatever you would say.
Yes, yeah.
So to tweak that language right there.
But I'm looking at this again. Mrs. Aldred. And isn't this section triggered in circumstances where the tribunal has asked the authorized officer to assist with the investigation of a complaint, which is different to what is in 10B? If we say that they can draw on the experts, so therefore a complaint comes before the tribunal looks at it and says we need the expertise of a social worker or whatever. Isn't that what 27 is? Because it speaks of investigation and report of findings to the tribunal where where a complaint appears to be well founded and is not frivolous. So I think that's a little different. That doesn't link to 10 at all, I'm thinking. That is where the tribunal.
Yeah, I think it should come out because it shouldn't refer to the authorized officer. Well, unless the authorized officer is not the same person being referred to in 10.
Or maybe
clear, because 10 already has its own process. Because if the person in 10, that authorized officer, has an issue, if you go to 10.3, then it can issue directions for compliance, and then it triggers a criminal offense. I think 10 in and of itself has its own process. This issue that's in 27, it cannot refer to the authorized officer as contemplated in 10. So I think the name would have to change. It can't be the authorized officer.
I agree. It will have to speak to somebody who the tribunal has requested to conduct an investigation. Don't speak about it, even if it can be an authorized officer. Don't speak to an authorized officer in that regard here. And I think that would clear it up, Chair.
Okay, thank you. Mr. Hunt, have you captured that?
Sorry, Minister, ask Mr. Silly Brown to repeat the last part of what she just said, please.
I'm just saying, show Ms. McCarthy, I'm just saying, rather than use the term authorized officer, which is defined and has a specific meaning in clause 27.1, we will just use words to the effect that the tribunal may authorize any person or may request that an individual conduct an investigation, and then it would follow from there, an investigation into a complaint, and in conducting the investigation, 27.2 would kick in, and you take out the use of authorized officer altogether, because the tribunal already has that right to request that persons can assist it in an investigation in the furtherance of its functions. So there's no need to just delete authorized officer, and we would find appropriate language to fill that particular provision.
Okay, thank you.
You're welcome.
So, Mrs. McCarthy?
Yes, Minister.
All right, Ms. Grant? Ms. Grant, you've captured that as well?
So, Chair, if I may, through you, to be clear, it's the intent to widen the scope.
Mrs. Seeley Brown? Oh,
well, I think, right. Well, it's to ensure that we have not taken something away. Let me put it that way. Not that we're widening. So there is a scheme in the bill. You have authorized officers that work with the Bureau, who are public officers. They can carry out an enforcement, a regulatory sort of function where they inspect workplaces, institutions, and ensure that there's compliance with certain matters under sections 3 and 4. However, the tribunal itself may need now, when they are dealing with a complaint, to do its own investigation and so on. They are given powers under 27.1, that's the tribunal, to engage and rely on any resource they need to undertake that investigation. It's just
I just wanted to be clear, because that was my understanding.
Right. But that investigation wouldn't be done by that officer, not necessarily. It wouldn't necessarily be done by that officer at the Bureau of Gender Affairs. Of course, I guess they could also give assistance if the tribunal requests it, but the tribunal is given some amount of latitude to call on resources and to deploy those resources. So the only issue will now be, of course, to ensure that the tribunal is adequately resourced from a financial perspective, but that's a different issue. That's a budgetary issue.
Yeah. All right. Thank you.
Thank you, Senator. Mrs. Seeley Brown?
So is the committee agreeing then, Chair, that we would delete paragraph B of subclause 1 of clause 10?
I'm sorry, Mrs. Seeley Brown?
That was my understanding.
Okay, that we
under your advice, yes?
Okay, thanks.
Yes, under your advice. Now, I noticed that, Ms. Grant, you there?
Yes, Chair, I'm here.
All right, you have captured all of that?
We're deleting subclause 10, paragraph B of 10.
Because remember now, we were looking at designation of authorized officers, and then further to that, we look at clause 10.3, proposal to expand for the period of compliance of authorized officers, not more than 30 days. And
that
yes,
that would not be affected, Chair, because that 10.3 was no strike at the heart of 3 and 4 of the bill, and 3 and 4 deal with an employer to take reasonable effort to ensure that the employee is not being sexually harassed, and the same duty in 4 for the institution. So I don't know, to my mind, I don't know if my colleagues feel differently, that would not be affected, SG, you think?
Yes, SG, go ahead.
Oh, no, I'm sorry. I'm not actually weighing into this discussion. I just wanted clarification on the decision of the committee to also include a provision allowing the authorized officer to enter premises, and so I wasn't sure if the decision was actually taken. So I just wanted clarification on that issue. Sorry.
Well, I think such a decision.
It was.
Yes, I think, yeah. Okay. I did mention it, Mrs. Aldred, and Chair agreed that we should insert it.
So back with you, Chair, about the point about 10.3. So in 10.3, the authorized officer is to secure the observance of
whatever is set out in 3 and 4, section 3 and 4, to ensure compliance. And 10.3 makes it clear that an authorized officer, on finding that a person is not in compliance with section 3 or 4, may issue a direction. So it would not be affected because the authorized officer would still have that duty. The authorized officer just could not investigate a complaint made by a complainant that I have been sexually harassed. At least that's how I see it.
Mrs. Celia Brown?
Yes, Chair, I agree. I agree with Mr. Bad Chair.
Right. Okay. Dr. Brownberg, you wanted to, Mrs. Celia Brown, you have your hand up. You wanted to make a further comment?
Sorry, Chair, I took it up.
Okay. All right, so in relation, we have agreed on the designation of authorized officers and made the necessary adjustment. We go on to clause 10, 3, the expansion, to expand to make the period of compliance with the direction of the authorized officer to read not more than 30 days. Ms. Grant?
Yes, sure.
Fine with that?
Yes, it was discussed by the committee that some time limit needed to be put on it, and the suggestion was not more than 30 days, but there was no decision.
So members, proposal to expand section 10.3 to make the period of compliance with the direction of an authorized officer to read not more than 30 days. We need a decision on that.
I agree.
Agree.
Chair.
All right.
Agreed.
Clause 10.4, committee noted the proposal to amend section 10.4 to significantly increase the fine to more than 1 million for an employer in breach. Committee did not accept the recommendation for the penalty to be increased in this section and stated that the section should remain as is, but that an officer should be added at section 5 to address increasing the penalty and would outline the reasons when or if the employer failed to act. That clause 10.4. I invite comments.
Chair, I'm not sure if I'm understanding the suggestion. How I'm hearing it is that the idea of increasing the fine was not accepted, but that later there should be a provision where the officer could make a case for increasing it. That I'm assuming therefore would need some changes in any case to the wording of 4. Am I correct?
Yes. Ms. Grant, you want to expand on that, please?
So 10.4, Chair, what was said was that we're not going to increase the fine, but in section 5 that imposes, clause 5 rather, that imposes the duty on the employer, that we should put a penalty there. I believe this was raised by Senator Gale at the time, that we put a penalty there in that section that would address instances, if they were to occur, where the employer failed to act. That's it, Chair.
Yeah, is that clear?
Chair, may I ask a quick question?
1 second. Dr. Bromberg, it's still not clear to you.
No, I'm really not clear, maybe because we have not worded it, so I'm not sure what the wording is, and therefore what the remedy would be, and whether or not that would be in keeping with increasing the fines as it relates to what the bill calls for, as opposed to the actual actions recommended by the authorized officer. So I'm still not sure.
Sure, maybe we'll try again.
Senator Longmore, I'll come back to you. I'm going to ask Ms. Grant to just explain again what this further what this means, clause 10.4, and what is suggested.
Yes, MP Brownberg, what was being said at the time was that whereas we have duties imposed, let me not use duties, but whereas we have provided for instances where false complaints can be made, where how we treat with complaints from complainants, that an employer, the fact that we have created a duty that the employer is to keep the environment free of sexual harassment, and we only say, okay, if you failed in this regard, then I can complain to the tribunal. But what said is that it's not sufficient for the complaint to go to the tribunal. The employer should be held liable for it.
Okay.
And so the suggestion was that we should include a penalty in that section where the employer, that would be triggered in an instance when an employer fails to do so, or if an employer fails to do that.
And that would also be in addition to what is provided for in 10, what is it, 4? That's 2 distinct actions or 2 distinct cases under which penalties could be levied.
It would be 2 distinct cases. Let me look back at 3 a moment. Because 3 and 4, 3 speaks to the employer taking every reasonable effort to ensure that the employees are not sexually harassed in the course of their employment, and then 4 goes on now to speak to the policy statement and the tenants there under the policy statement. So 3 and 4, which is what 10.3 relate to, speak to where the employer fails in that regard. So there are 2 different things.
Okay. Okay. All right. Thank you very much, Ms. Grant.
Yeah, okay. Thank you. Senator Longmore.
Thank you, Chair. I'm a little bit jumbled with respect to the joint select on tobacco, where, or if it was here, the discussion was had in terms of graduated fines for repeat offenders or persons who fail to respond repeatedly. So I don't know if that is relevant here. Like in that bill to the infringements that might happen on a repeat case basis. So just throwing that in the mix. That's why I kind of wanted to ask when Ms. Grant was responding to Dr. Brownberg. Thank you.
All right, Ms. Grant.
Senator Longmore, may I just apologize to you? I got lost in translation just now. Could you just repeat for me, please?
I was asking around repeat offenders in terms of if the person had a previous issue brought to the tribunal, and let's say the same thing happens again. Is it the same fines that would apply, or I can't remember if it was here or elsewhere. I'm just drawing the analogy to the tobacco control bill, where there is a graduated and increase in fine for repeat offenses of the act. So I wondered, in this scenario, let's say the person was brought to the tribunal, and again 2 years down the road another case is brought, etc., etc. My question. Thank you.
As far as I recall, and I'm searching through the bill as I respond to you, the bill doesn't have anything that deals with where a subsequent case of sexual harassment comes before the tribunal involving the same person. I will say though that 34C, as is currently crafted, 34.1C, could
No, please, I'm in a meeting.
34(1)(c), Senator, could take such a situation into account, which gives the tribunal the power to make any such award as may be appropriate in relation to the complaint. So if such a situation appears before the tribunal and the tribunal recognizes that this is not the first time that this person has been brought here on an allegation for sexual harassment and they go through, then they will so make the award in line with that and other variables. So I think your concern there could fit there.
Okay. Thank you, Senator Longmire. Thank you, Ms. Grant. So we are agreed committee that where the employer failed to act. Ms. Grant, do you want to just outline exactly what we have agreed to so that we can sign off?
Sure, Chair.
In relation to
10.4,
yes,
that we're going to insert a provision at 5, that's in clause 5, that would create a penalty where an employer fails to, I'll just go back to 5, where an employer fails to take immediate and appropriate action to deal with a complaint of sexual harassment. That's how I understand it, Chair.
that a penalty would be imposed here. All right. So members, is that clear?
Yes, Chair.
Sorry though, Chair, I'm really sorry to waiting now. So when you create an offense, rule of law says it has to be very clear, it has to be very specific. Immediate and appropriate action is not very specific, and it's left to too much interpretation. It would not be able to be crafted that way if we're creating the offense. And then 10.3 speaks about the timeline. So if you're going to create an offense, you need to have the timeline that was not complied with. But to use that terminology would not be appropriate for a criminal offense. You would have to have, it would have been failing to comply with a direction that should have been done within a very specific timeline. So the summary that I heard a while ago, I would have a concern if the instructions are being given to the drafter to craft it in that way because it is too vague.
So it's either we create an offense or we don't create an offense, depending on what the committee agrees with.
I see Mrs. Simons.
Yes, I just had a query. I thought the penalty for immediate and appropriate, I thought that was going to be dealt with under clause 5. I thought that was what was agreed, that Mrs. Brown was going to look at the language because there was the proposal for a timeline to be used there. And she was also going to look at the penalty right there. And that was agreed in the last meeting. So I'm a bit unclear as to the proposal for a new subsection 5 under clause 10.
I
thought we had done. Go ahead, Mrs. Philip.
So I'm saying I don't have that in my notes. I don't know if I've missed it with respect to clause 5, Chair.
I thought you were going to do something with clause 5, because clause 5 too, that the immediate and appropriate, there is a penalty there. It says shall be liable for failure to act. So I thought the penalty was going to go there.
No, I think we had agreed, if I'm, let me turn on my camera, sorry. I thought we had agreed that we were going to tweak it, not to make it a criminal offense, but to allow the person to make a complaint.
To go before the tribunal.
Yeah, that's what I remember, Erica.
That's what I recall suggesting.
Yeah.
At the last meeting.
Be a criminal offense.
Not for it to be a criminal offense, but treat it as a civil matter, right. And for the benefit to be expressed at the level of the tribunal, where the complainant can benefit.
So if it's going to go before the tribunal, then why would we be putting a penalty in clause 10?
Sure, just as is. Oh, I'm sorry, Mrs. Cedar Brown. Go ahead.
Ms. Simon, the penalty would be would be in respect of you failing to comply with a direction given by an authorized officer in relation to clause 3 and 4, which deals with compliance with your internal mechanisms and you're having your policy and that sort of thing. Nothing to do with clause 5, Ms. Simon. It would be with
I thought that was 4.
No, that would be clause 4, which deals with the clause 4 deals with the duty of the employer to institute that policy statement, and 3 would be to have your workplace free from sexual harassment.
So,
so that's different.
If I may, it would appear then, based on what has been said by Senator Gale and my other colleagues from the technical team, that 10, was it 10? No, 5, that penalty section would no longer be needed then.
In 5, for 5?
For 5.
Not criminal.
Right, yeah.
Yeah. And Ms. Grant, if you would remember, we there's no penalty right now, it just says liable for failure to act, and they make a complaint before the tribunal.
Yes.
Yeah, so that's fine.
Okay, so no criminal penalty in 5 then, sure.
No.
Okay. All right, so we now move on to.
So I'm sorry then, Chair. So what's the decision as it relates to what was being discussed earlier? Read 10 and the timeline?
Ms. Grant, what have you captured?
The timeline 10 for 10-3, not more than 30 days, SG. That one?
No, there was some other issue about urgent and immediate. I thought also under 10, which I didn't understand.
Which is 10-4?
10.
I thought you said a new sub 5.
No, that was in relation to clause 5, the penalty section.
Oh, okay.
So, and the decision is no penalty.
No penalty.
No criminal sanctions.
Right. Mrs. Simon?
Just was wondering, I have a note, but I just wanted clarification that there was an issue raised with the use of may in clause 3 and a proposal that it be changed to shall, and I just wanted to know what was the decision on that.
Ms. Grant?
I don't recall that, Chair, but I'm looking.
Ms. McCarthy?
We can change the views up here.
I think there was a discussion about that it shouldn't be, left to their discretion, that it should be something mandatory, that they should issue the direction should be issued. I don't know if it was agreed, but I remember a discussion about the use of may.
So, Ms. Simon, can you say which 10-3?
10-3, yes.
Where's the word may? You mean may issue a direction?
Yeah, I remember there was a discussion, but I don't know.
It can't be shall check. It can't be shall check.
20-something. The last one I had this morning was 100 and something.
I'm just not sure what was the decision on that.
143. That's as
Sorry, is it that someone raised a concern about the use of the word may? And I don't understand the context of the concern, because you don't usually use the word shall in this type of context when saying that an authorized officer is to carry out so it's an admin law principle, but I don't understand the concern.
No, I think I don't have the concern. I think I remember it being raised. So I just wanted to ask. But since, based on what you have said, that normally in admin law it would not be used, I have no issue. I just wanted clarity.
Okay, thank you, Mrs. Simon. So we now move on to clause 11. Establishment and constitution of tribunal. Committee noted various proposals from different entities to amend the composition of the tribunal in clause 11. After extensive deliberations, the committee recommended an increase in the membership of the tribunal from 12 to 14. Committee also agreed to accept the recommendations that the tribunal comprises members with expertise in worker representative, trade unionist, gender affairs, mental health, employer representatives, certified mediators, and other areas that will relate to the tribunal. Committee further agreed that there would be no cap on any of the professions comprising the tribunal. The committee had not made any decision on this. So I would ask for consideration be given here and for us to decide. Do you want me to read this again? Establishment and constitution of the tribunal.
I am in agreement with the new proposed adjustments, Chair.
And the adjustments as stated?
As outlined.
Right.
Chair, we had a lengthy discussion on it. I really don't know why we never made a decision. But I'm in agreement with what was proposed, having gone through that extensive discussion.
Good. So say all of us?
So say all of us.
Thank you. All right, now gender balance on the tribunal. Committee discussed the proposal that the tribunal include minimum of 5 members from each gender and a panel of 3 to include 1 of each gender for hearings. We need to make a decision on this. So say all of us?
I'm in support of that.
Aye.
Very good. Appointments to vacancies. Committee noted that appointments to vacancies should meet the overall standard set in section 2. Ms. Grant, you want to just expand on that, please?
Sure, Chair. The overall standards as set out in section 11, it was brought up that there.
11, I'm sorry.
Okay, it was brought up that there's nothing to indicate that vacancies would be filled the same way initial appointments were made, and that was put on the table. The committee did express support for that, but I believe the committee clerk was not sure if a decision had been made or not.
So Chair, if you would have qualified for coming in one particular way, that should constitute how we fill vacancies.
Yes.
So in my mind, agreed.
Yes.
Just to be sure, just to be clear.
I think we all can agree on that. Should meet the overall standards set out in section 11. So we can agree on that?
Yes. I'm in agreement, Chair.
Okay. All right, provisions to insert a provision for boards. The committee recommended that a standalone provision be inserted to deal with harassment from board members toward workers, chairpersons of boards toward board members, and board members toward board members. The committee stated that board members should be recognized in the act as their service on boards would amount to work. Committee had asked for the technical team to advise and that we should look further at this matter. I'm going to ask Ms. Grant to expand on this and for us to discuss and make a decision. Go ahead, Ms. Grant.
Thank you. Thank you so much, Chair. All right. The last time we left this point, the committee, to the best of my recollection, indicated that that consideration should be given to to boards being a specific provision be inserted in the legislation to deal with possible cases of harassment that occur between board members, and the rationale was that board members are working. Having taken some time, Chair, to ruminate on what the committee's preference, a few things I'd like to put before the committee. We have to remember how a lot of boards are appointed. In a board and its constitution and how you should treat with it, because as defined under the Companies Act, then a board is a board. But then in other circles where the Companies Act does not apply, we have to remember how a lot of boards are appointed. And boards can take various forms. Boards simplicity, where it is obvious that it is a board. And then we have other forms of boards, and I use boards loosely. We have advisory committees, we have advisory bodies, oversight bodies, management bodies. So we were not, there was no indication as to, number one, how we would define a board. If you would take in, when we say board, the many variants that boards can exist. And also, coming from the employment standpoint, which was really the essential theme that underpinned the suggestion, where in an employer-employee context, an employer has a duty to ensure that his employees, that the employees are not sexually harassed. In cases of boards, to whom would such a report be made? Would it be, especially, would your first point of complaint, it could not be the chairman to my mind, because the chairman is not your employer. So who then would you complain to? It would be whomever has appointed you. And as I said, if we extend our minds to how a lot of boards are appointed in familiar circles, to put it mildly, that duty, that employment duty, could very well devolve on a minister to I mean, this duty that we're imposing on employers to ensure that the environment is free of sexual harassment, who operates as the face of another body. So I just want us to when we think about it, to think about, if we're going to get so granular, what could how we would address the many sides to this, or if it would be sufficient to look in the legislation to see what clauses could deal with it, giving it a wider ambit instead of being so granular. And those are my few words. Thank you, Chair.
Thank you, Ms. Grant. I will invite Dr. Angela Brown-Burke and then Senator Campbell Rodriguez.
Minister, I think I actually saw Senator Campbell Rodriguez's hand up, notwithstanding. But okay, let me go first. You know, I appreciate Ms. Grant's drawing our attention to the problematic, how problematic it could be. I am hoping that I'm correct, that I'm not reading into that should deter us from providing protection for the members of the board. I believe that, as we discussed the last time around, how we would protect a board member, and we went through various scenarios and so on, that we are duty bound to find a remedy. So I remember also we were asking whether or not there were provisions in the bill as it was that would be able, that we could rely on for such protection. I think we had started out thinking that it would have been there, and then based on the discussion, it was obvious that it was not there. I'm not sure where Ms. Grant is coming down, but I'm hoping that a suggestion will be made as to how we can protect our members. Because can I tell you, especially because we know how, we understand the various modalities in terms of the appointment of board and so on. We also understand where the minister actually appoints the board. But let us also be very clear that the fact that the minister appoints these members don't mean that these members give up their right not to be harassed, sexually harassed in the completion of the responsibilities or fulfillment of the responsibilities that they have been asked to carry out. So I want us to be very, very careful, because I believe that a lot of like a decision like this is a signal as to where we stand as it relates to sexual harassment. And there's no one who is asked to suffer in silence simply because they were appointed by the minister or because of who the perpetrator is or anything of the sort. And so I think that we need to find the remedy here.
Thank you, Dr. Brownberg. Go ahead, Senator Campbell Rodriguez.
Thank you, Minister, and thank you, Ms. Brown, for your comments on this issue. But similar to Dr. Brownberg, I don't think the solution can be to not do it because you're appointed by a minister. It is to find a solution that will work. I think having been appointed by a minister, most ministers would want to protect persons they appoint because there could be a backlash from it. So it's to find a solution. And in the last meeting, we debated this issue when I raised it, and we agreed it needed to be done. What we did not have was the wording. So I don't think we need to go back to debating whether or not it should be done because we had agreed at that point. But I think also that to say it has to be the minister who handles it, it's a stretch because having sat on boards, I have gotten more correspondence from the permanent secretary in ministries than I have from the minister who may have appointed me. And with the new PBMA laws coming, I'm not sure we need to tie it to ministers as much because the processes will be a little bit different to some extent. And also we had agreed in the last meeting that board members are not employees. So in my mind, the matter would be reported to the chairman of the board. I'm not clear as to why it can't be the chairman because they're not employees per se by the definition of an employee. So I'm not sure why it couldn't go through the chairman and the chairman then to the permanent secretary. It does not have to be the ministers from my reading, but I stand to be guided.
Thank you, Senator. Ms. Grant, I saw your hand up.
Chair, I'm still processing. I will speak shortly.
Sorry, Chair, just to respond to one very small point about the permanent secretary's involvement. The law is clear. The permanent secretaries actually do not, even though you may, yes, it's true, they perform to an extent an administrative function in, say, mail and in terms of correspondence and all of that. Boards do not report to permanent secretaries, which has been an issue, and that issue is actually not yet addressed in law, and it's creating a problem. And I recall a very vociferous permanent secretary making that point very clear before a specific committee of Parliament. So the responsibility in law is not given to the permanent secretary, and we wouldn't be able to make that kind of provision here without an amendment or so to the PBMA or maybe even the FAA Act, and maybe even the Executive Agencies Act as well. It's a separate issue. So just on that point with the involvement of the permanent secretary, that wouldn't be easily resolved under this law. My own little comment on this.
Noted. Thank you.
Just sorry, Chair, just also to add Chair, to what Member Rodriguez Campbell was saying. Let us also consider a situation, because you speak of the complaint going to the chairperson. While we're having that discussion, let's also speak of a situation where the chairperson is the person who is doing the harassing. There must be a mechanism to deal with that too. I'm just throwing it out there so that when we have our discussions and we're ready to tweak the draft, that we take all these things into consideration.
Yes, definitely there needs to be a mechanism to deal with that. And so I would ask for Ms. Grant that you
Just to say, Chair, in addition to what my colleagues have already said, that the committee would also need to decide on how we define boards. Are we going to, is it going to be board simplicity, a board where you can obviously see that it is a board? Or when we say board, are we going to include oversight bodies? Are we going to include, the different variants of boards? And what allows for us to be so specific, for want of a better word, in singling out boards? What happens to partnerships? What happens to all these other entities in which work happens? I just want us to keep that in mind. I foresee, and SGU could tell me if I am not correct here, but that if we want to be so singular in our approach, so to speak, we could open ourselves up to a constitutional challenge. Just for consideration.
Okay, how do we treat with bodies that have oversight? How do we treat with bodies that have oversight? Are we saying those bodies that have oversight of a particular entity, if members on that body, including the chair, make sexual advances, they're exempt? That's a question we need to ask. Now, I see Senator Gale's hand up, and I see Mrs. Seeley Brown. I'll take Mrs. Seeley Brown, then Senator Gale, then Senator Longmore.
I just wanted to say, Chair, and I think you raised it somewhat. It is easier when you're dealing with a board that is established under the Companies Act, under that statute, to say members of a board. But remember, when we're dealing with legislation, pursuant to Section 20 of our Interpretation Act, you establish bodies as statutory authorities. That may be a little easier too, because you say that this is a statutory authority and this body is governed by a board. However, there are other pieces of legislation that would have different types of bodies, an oversight body, or like, for instance, the commission that we have established under the Integrity Commission Act. So it may not be a board, but it conducts those functions that are related to a board or the oversight committee under our MOCA Act. And remember, the mischief of this act is to provide for an environment that is free of sexual harassment. So I think what Ms. Grant is trying to say is, if we are going to speak to boards, and we have to carefully look at how we are going to define boards. I think the other thing we need to look at, Chair, is that, remember, the scheme of our bill as it currently is drafted speaks to the employer and employees, the worker and employee situation. And we have already agreed that these board members are not workers. So when you look, for instance, because you remember, when you insert things in legislation, it must work and there must be a remedy if somebody brings a claim. The way the scheme of the bill is drafted now, it centers around employer, worker, person in an institution, and a person in accommodation. When, because the decision has taken that you're going to insert it, when we insert that provision now to deal with that, with boards or however we define it, we have to offer that same type of protection, that environment that is free of sexual harassment and the like in relation to those persons. And Ms. Grant's question, to which I think the committee needs to decide, is who has that liability? Bearing in mind that it can't be the permanent secretary, because the boards are not answered to permanent secretaries. Who has that liability to ensure that that environment is free of sexual harassment? And where that is breached, how does this member now approach the tribunal? Because of course, there are no internal mechanisms in that regard, because it's not, the scheme of the act is not set up to deal with that particular composition. So I would like the committee, when you're making your decision, to consider all of these things, so that we can be guided when we are doing the amendments that are required. Thank you, Chair.
Thank you, Senator Gale.
Here, you know, you open a door of a room and turn on the light, you have to enter. And so with what Mrs. Seeley Brown has expressed earlier, we can't now turn back, but we have to seek guidance. 7 clause 7, 8, and 9 expressively states about all the issues in relation to those who would have been exposed to sexual harassment. Now, what we're saying is that board members would constitute part of the workplace, part of that environment. And we would have already protected the employees if they were harassed by board members in terms of clause 5, for instance, what is contained in clause 5 in terms of the duty of the employer to take action. It becomes more complex now when this is the relationship between board member to board member in terms of the harassment and who is to be accountable. And then we spoke about the different types of boards now. The private sector board that would have been established in terms of the board members by shareholders appointing board members, and the statutory bodies or the public bodies or the public sector boards that is appointed by a minister, and those other operational type boards like the advisory boards and the school boards. All of them are boards. And so for the protection against the harassment, when we define boards, we have to include all of them. The issue is who we know asks to intervene in these matters. And in my mind, I'm still suggesting that it is the duty of the employer to act, irrespective of or irregardless of the fact that is a chairman of the board who is seeking to harass another board member or vice versa. It is the duty of the employer to act because the internal mechanism is established within the organization. So wherever it takes place, wherever the occurrences, whomsoever is the aggressor, the instruct ought to be that the employer or the institution is going to have to respond, because that is where the internal mechanism is established.
Thank you,
I'm
Senator.
still processing it,
Yes.
but those would have been my initial thoughts.
Good. This is not an easy one.
I know it's not. I have been grappling with it too. I'm glad that it was Miss Grant who raised it, because I was wondering how I was going to raise it.
Okay, I'm going to ask Mrs. Seeley Brown, and then I will recognize Senator Fraser-Binns.
Thank you, Chair. Just to say that in jurisdictions where they have become so granular, they have really become granular. So you deal with partnerships, and we have a partnership act. So we have to bear that in mind, and we have very different partnerships. They deal with members of clubs, of institutions, of associations, you understand? So so the scheme is a little different to what we have drafted. It is much wider, and they deal with every aspect. And I think, Ms. Grant, if you look at the Sex Discrimination Act 1984 of Australia, you'll see how granular they've become, but it's a different scheme, Chair, which doesn't deal with sexual harassment in the workplace, institution, or whatever. So the scheme is much wider. So I would just want to put that out there for the committee to consider when you are having your discussions, that it can be done, but it's with a different scheme, and you become very, because you don't want to do something to the exclusion of another body. And then somebody say, but this is not equality before the law. Why boards and not clubs? Why boards and not other associations? So they have become very, that legislation is very, very detailed and granular with respect to every group that can be harassed. So that is just something else for you to think about while the committee is considering, Chair.
Well, Mrs. Seeley Brown, we're going to be depending on the drafters to give us a roadmap through this one. Senator Fraser-Binns?
Thank you, Minister. And I'm happy I'm speaking after Senator Gale, because he raised one of the concerns that I had. And I haven't quite worked through my mind, but I was just wondering, and this is more for the technical team, because in Ms. Grant's presentation, she spoke a lot about the public board, which I completely understand, and there are other types of board. And I wondered whether in seeking, because we are all agreed that it is a matter that must be covered, and in seeking to find a resolution, I'm just wondering whether it could be that in the instance of a board member harassing an employee, it's very clear in my mind that the report is made to the employer. So that is clear whether it's going to be the executive director or the permanent secretary, sorry, the executive director or the managing director of that entity, whether public or private. In the instance of a board member harassing a fellow board member, I wondered whether, because the minister is the one who does the appointment in the public bodies, whether the report made to the minister and the minister could have a delegated function, a power, to delegate that responsibility, whether to the PS or back to the employer to investigate. I don't know, Mrs. Seeley Brown, you can offer some guidance from your experience and where you sit. But I'm just thinking if that was an option that we could explore in trying to resolve the matter.
Thank you, Senator Binns. Mrs. Seeley Brown?
Chair, I'm not so sure at this point how to answer, because these things are still fresh, and with the technical team have been having discussions, and these things are still, we still requiring some policy guidance on these issues before we can properly advise you as to the best way forward. As I said to you, it can be done. My concern really is just the scheme of the bill currently and how it speaks to that employer-worker relationship and how we fit it in when we've decided who we're going to be including, and whether we should go wider and become much more granular and deal with everything, or whether we should stick to boards established by statutes or bodies that have functioned similar to a board under a statute, and of course the private boards, which are much easier. So I don't have an easy answer to that question, Senator. I'm sorry. It's something that the committee, that the technical team, we have been discussing and we're still thinking about, but we would still need more guidance as to what types of bodies we are going to be including, especially when it comes to bodies that are established by statute, because maybe you have committees, management committees, commissions, oversight bodies, and these things function somewhat like boards, statutory boards. So it's still a little difficult for me to respond to you with any more clarity. Sorry, Senator Binns.
I understand. I'm just putting it there for consideration when we get there. Thank you.
Mrs. Seeley Brown, this one is really not an easy one, and we're really going to have to depend on you and the drafters for some guidance. But the reality is that oversight bodies, boards, and such entities do have diverse compositions, and the reality is that colleague board members can also harass each other, sexually harass each other. It's a reality. And so this one is difficult to address, but we're gonna have to find a way to address it. So I think at this point.
Chair, before you move on, please, Chair.
Go ahead.
I'm sorry, before you move on, maybe, Chair, I think this is now time for us to call on the expertise of the Legal Reform Department. I think it requires some research with respect to, because I'm not seeing anything apart from, as I said to you, South Australia. I'm not seeing anything where it is dealt with in that way in other legislation. So I think it is time now for us to basically ask for the assistance of the Legal Reform Department for them to put together something for us to consider as to, because remember, we're not just thinking of who we included, but how do we provide for a mechanism so that the legislation works? Because you don't want to have provisions where, Chair, you can make a complaint or you can, but it doesn't work to the person's advantage, that person who's been sexually harassed. And I think it is now time for us to have them sit down and advise us as to how we can include it and how then can we fit, because it's going to have to be a new mechanism into this bill to deal with those persons who are not in that employer-worker type of relationship. Because we now widen in large respect, Chair, the scheme of the original bill. So it would require some research on their end, Chair.
Yeah, I see Mrs. Simon's hand up. Could you please go ahead, Mrs. Simon?
Yes, yes, Chair. I just wanted to say that I did look into the matter since it was raised, but I too have yet to find anything, any other jurisdiction making provision concerning boards. I'm also too unsure as to how they should be approached.
So, Mrs. Simon, I'm going to depend on legal reform to come back to us. I won't delay our discussions any further on this particular aspect or this particular provision that we are trying to resolve, but to ask legal reform and the rest of the technical team to really do further research and discussion and consultations and come back to us as to how we can deal with this. Agreed, members?
Yes. Minister, just to clarify, Minister, so if it's okay with you, so the technical team is going to come up with how we can word it and fit it in versus whether or not we should. I just want to be sure we have signed off that we should, and it's now just to find out how to do it.
I think it's difficult to sign off that we should.
Okay.
We know what we would
Sorry,
like,
Chair, though.
but I think we have to be advised. Can we come up with a mechanism to do so? And so we have to allow them to come back to us. Go ahead, SG.
Okay.
Right, but what have you agreed to? Meaning which bodies? I think that's the bigger issue we are having. We can't do the wording if we are still unclear as to which bodies this is to apply to. Because even if you use the word board, which board? Remember, you have boards of companies that are registered under the Companies Act. You have boards that are governing companies, bodies, entities that are established under statute, meaning corporate bodies that have powers under Section 28 of the Interpretation Act. Is it just boards so-called and so named, or are you talking about oversight entities? Because a board is an oversight entity. I'm just saying we are also not clear as to which entities you would want this to apply to. And that is the reason Mrs. Celia Brown was raising the variations, because you see, there are different legal implications if you talk about the different variations. And that is when you may need to now get granular. So we would need, when Mrs. Celia Brown said we needed the policy direction, it's along those lines that we're talking about.
Thank you, SG. I'll invite Senator Campbell Rodriguez and MP Angela Brownberg.
Minister, I think Senator Dr. Longmore was before me.
Yes, Senator Longmore, please go ahead.
Thank you, Chair. Just a consideration that maybe we could use the terminology positions of appointment, and also just to also remind us of the fact that we have that 5-year review process. This is a first attempt, so to speak, and we have that avenue where we can, in our, especially our public education campaign, highlight the fact that this is an area that we also would want to see the extension of the provisions, et cetera, or just emphasize the role that we would hope that the responsibility that those persons play, and also take it into the review process when we get there. But just to also suggest positions of appointment, and that I think may also cover the what we're trying to capture.
Thank you, Senator Longmore. I'll take Senator Campbell Rodriguez, MP Angela Brown-Burke, and Minister Johnson Smith in that order.
Thank you, Minister. Just to say that if possible, it would be good to protect all board members. You know, I hear the concern that there are many different types of boards and formations of boards, but I think we're trying to protect all people as best as possible in the workspace. So if it is possible, we could go that route, or if there's a recommendation from the technical team as to those who we should be focused on, because until it was raised, I assumed we were going to look at all of them. But if there's a reason we can't, if that could be explained, that would probably help me personally to make a decision.
Thank you, Senator Campbell Rodriguez. Dr. Angela Brown-Burke.
Thank you, Madam Chair. From my perspective, I believe that everyone really should be covered. I would believe that, and I'm thinking of all oversight bodies. And I say that because, yes, we are looking at the employer, we're looking at the workspace, but anyone that has been appointed to assist in what is happening, you know, in the governance of an entity, I believe needs to be protected. And I also believe that we have to provide protection of others from them, just in case any of, you know, there is any breach of the matters that we are considering. I really don't have a specific suggestion as to how to address it. I am to be guided. My bigger point is that all the individuals that would have a role to play in the functioning of the entity, I believe we should find a way to cover them.
Thank you, Dr. Brown-Burke. Senator Longmore, please put your camera on. Thank you.
Hi, Madam Chair, thank you. I think I was next in line, so.
Okay, I'm sorry.
Right, yes. Sorry, just on this point, I don't have a specific suggestion, but I do think that this sense of the discussions that we have been having have been around ensuring that the work environment is captured wherever it might exist. And I think that a part of the challenge that we're having is that we are perhaps becoming so descriptive about where that exists that it may pose a challenge down the road. So the views just expressed by my three colleagues who spoke regarding ensuring that positions which are appointed positions are not excluded by the definition of worker, or that the concept of the work environment is not prescribed in a way that would exclude circumstances where you are in a position of oversight. I think that if we start to say whether you're an oversight body or you're a public board or you're a private board, etc., I don't think that's necessary, because I think it will it'll cause unintended consequences in terms of interpretation, and it's going to narrow the interpretation of a work environment. Because remember, we're also discussing the fact that the work environment will include virtual spaces. So it must be that our thinking is beyond the actual role of the person, the function in which they work, as opposed to the fact that they are working, they are in a work environment, whether it is they're being served or they're a part of a team or they are in a position of power or a position of vulnerability, of greater vulnerability. Either way, we want to capture all persons from and protect them from harassment. So I think maybe if the technical team is looking back again, I don't think we should be going into partnerships versus company and private sector versus and club versus. I think all of that takes us down a path of not only changing the scheme so totally that, you know, you're going to find little gaps popping up all over the place and further delay us and maybe create loopholes. But I think that also maybe going back to that original concept of ensuring that the language is so agnostic that it is as protective as possible. And we'll be able to argue that a case that we had not anticipated, but one which clearly fits within the scope of the bill and the intention of the bill, the protective intention of it, that we would not inadvertently, exclude those circumstances or those persons. So I think the intention, and Senator Campbell Rodriguez, when you raised it, and it is an important issue, you raised the issue of boards. I know that you were speaking of an expansive approach to the bill, as opposed to identifying that a director must be. So I hope that my submission is supporting yours and the others about expanding.
Yes, it is. Thank you.
Thank you, Minister Johnson-Smith. Senator Longmore.
Sorry, Chair. My hand, I should just lower it. Sorry.
Okay, so we have, I think I'll just go back to what I had said originally, that I'm asking legal reform and the rest of the technical team to, they've noted all that we have said and to come back to us.
Sorry, Chair, if I can just interject, yes. I'm not sure that the AGC can assist here because you see, our position would be you have to have what is already in the bill. You see, it's very specific as it relates to who is covered. You have to be careful when you make it nebulous and vague because then it's the responsibility and duty won't attach to anyone. And remember that we do have criminal offenses that attach, so it can't be, we can't do the general sort of catch-all. And this is the reason we were asking for more guidance. I have to say, I think this is a matter more for legal reform to maybe come up then with some sort of model, because this is going outside of what we already have in the bill. So they would have to come up with a model to address this situation, which is going outside of what's currently reflecting the policy of you see, when I spoke earlier, not this meeting but another meeting, we talk about workplace, that's not even really the language of the bill. So again, to me, I understand the concerns, but it is going wider, and so this is something now for really legal reform to come up with a model for this further discussion with the members of the committee.
SG, I hear you. I would ask legal reform to see what they can come up with. I will go ahead and look at other areas where we were to make decisions and try to go through those before we close off today, and just to ask legal reform to see how they can address this concern or this provision, because there is a strong desire on the part of the committee for us to exhaust all considerations to see how we can include this. And based on advice, in the end, we'll have to make a decision one way or another. Did you want to say something else, SG?
No, Chair. No, no.
All right. So members, you agree that we ask legal reform to see what they can come up with, and we move on to the other areas where we need to make a decision? Members?
Yes,
Agreed,
Chair.
Minister, agreed.
Okay. All right. So clause 34(1)(b), variation or termination of a contract or agreement. The committee did not decide if this award by the tribunal was an appropriate award. 34(1)(b)(5). Direction that variation or termination of a contract or agreement, if this award by the tribunal was an appropriate award. Senator Gailey wanted to make a comment here.
Chair, if in the course of the proceedings, the complainant contract was varied in any way, shape, or form, then there ought to be some sort of a reinstatement of that as a possible award. But I'm not sure if this is what this particular clause is saying. A direction that the termination of a contract or agreement should be varied to redress any loss or damage suffered by the complainant.
Okay, Ms.
Is it that you're going to seek to improve the terms and conditions of employment as a means of addressing the complaint?
Ms. Grant, could you expand on this?
Well, Senator, I'm not sure what is anticipated. Well, maybe not, but this point, if you recall, was brought up by you initially. And
this one?
Yes, this one. And what you had asked was how would the tribunal provide for that? What would account or what would authorize them to say, okay, how is the contract going to be so terminated or varied? How would they do that? And the question on the table, I believe, was this even an appropriate award for them to make in the circumstances? Should it be there? It was discussed to some extent. I don't have it as being agreed. Mrs. McCarthy doesn't have it as being agreed. So it is, should it be there at all? Should it?
Well, you see, sometimes the mind is of such that you query so many things that you don't recall what you may have queried. But in this case, in looking at it again, I don't know why it's there. It may do more harm than good in the final analysis.
Can anyone else from the technical team explain?
What? Maybe we could start by asking ourselves, what would be the motive for having it there? What was it seeking to achieve?
I believe the mischief that this was intending to cure in instances where a person is, what I get from it is wrongfully terminated. That's what I get from 5. A direction that the termination of a contract or agreement should be varied to redress any loss or damage suffered to the complainant. But if so, well,
All right. So if that is the situation, then this should be an add-on to reinstatement, and where such reinstatement would ensure that the person would not have lost any benefit or payment. So in terms of the Industrial Disputes Tribunal, who would reinstate an employee who may have been unfairly dismissed, the tribunal award would indicate that they be reinstated with no loss of benefits or payment. So I don't know if that is what this is trying to capture.
I see Mrs. Seeley Brown on share. I'm not sure if you'd want to hear from her. I'm going to look on the CARICOM model bill in the interim.
I will never reject hearing from Mrs. Seeley Brown.
Go ahead, Mrs. Seeley Brown.
Chair, I have no response to this one. I'm just trying to see if I can. No response right now, Chair.
No response right now.
But if that's what it is seeking to do in order to ensure that the individual would not have lost anything by virtue if they were terminated.
Well, I would say that Ms. Grant, you could come back to us on this one. Okay? While we move on to the next point where we needed a decision. And that is behavior modification of perpetrators. Committee considered whether there should be a provision inserted that deals with behavior modification mandated for perpetrators where it is found that sexual harassment occurred. The committee to decide if such an insertion should be made or if that is already covered in 34(1)(c) of the bill. Ms. Grant? Yeah, you may wish to expand on this and invite.
You said something about behavior modification, Chair?
That's right.
Okay,
if this should be inserted, or if it's already covered in 34(1)(c) of the bill.
Okay, so this contribution came from, I don't remember which entity, Labor Studies or one of them, I think it's Labor Studies, Hugh Shearer. They indicated that there is nothing in the bill to address behavior modification of a perpetrator. I was looking at it, Chair, and yes, there's no express reference, but then I'm wondering if 34(1)(c) wouldn't take care of that, make such other award as may be appropriate in relation to the complaint. So though not specifically stated, the tribunal does have powers outside of what we have here to make any such other awards. So I'm wondering if it needs to be included at all.
Okay, thank you, Ms. Grant. I will recognize Senator Cameron Rodriguez and then Senator Fraser Beans.
Thank you, Minister. Just to say that, firstly, if we're going to include it, we have to change the name, the term, the tag term. Behavior modification as a phrase has a negative connotation in some quarters. So we'd have to change, but I understand what it is that we're trying, the group that submitted this, what they're trying to say is, do we seek help for the persons who have sexually harassed other persons? Is it that we're saying they should do some hours of therapy or something along that lines? And if that was the intention, I don't see how 34(1)(c) would help that, because that make other award. An award is something positive and not punitive. But again, maybe that's my non-legal interpretation. So I'm thinking it would need its own section. Myself, I'm not convinced as yet, but I'm open to listening as to whether or not we need this component in the bill. But if we agree in the end, it couldn't fit under that clause in my mind, and it would have to change the name.
Chair,
Thank you. Go ahead.
I have in my notes, Chair, I don't know, I have in my notes that the decision was taken to insert a provision to deal with psychological counseling for persons affected and the perpetrator. So I don't know, and I have it as being agreed, so I'm not sure, Chair.
Oh, okay.
Because we had already stated that it may not come on the sea, and committee members were saying that they wanted a specific provision to deal with that aspect, Chair. So I have it as something that needs to be included.
Okay.
Minister.
Brown, what all right, so we note that, but I will allow Senator Fraser Binns to make a comment, Senator Gale, and then I'll go back to Senator Campbell Rodriguez.
Thank you, Minister. I'm happy Mrs. Celia Brown said that. It may have missed me because I was actually going to make an intervention for an express provision for counseling, therapy, psycho-assessment, something to be done. And I say that because if you go back to the fact that this is a very new bill, we go back to the fact that it is a radical change in bill. And even the issue of counseling or prescribing counseling is not something that comes by route. You know, it is a new culture that we're developing. And if we want to change lives and change culture, then in my mind, a part of it has to be with counseling. And so I wanted to make an intervention that I believe that an express provision should be made that counseling should be offered both to the victim and the perpetrator.
Well, thank you, Senator Fraser Binns. Senator Gale?
Chair, if there is a behavior that is being perpetrated that is unwarranted, it requires some modification to that behavior to which you might not be able to control on your own. And so help would be required. And I've seen in some workplace policies that having identified, having presented itself, and having determined there's an instruction that the perpetrators either get counseling, go through some sort of a training, go through some sort of, even to read again the code of conduct. But there's a direction to which that perpetrator would have to undergo. And if it's explicitly stated in some workplace policies, then there is absolutely no harm in creating a defined provision in this bill to instruct such behavioral change.
Thank you, Senator Gale. Senator Campbell Rodriguez?
Thank you. I agree that it is needed, but I ask us to think about something. I'm not necessarily saying these granular details need to go in the bill, but I'm asking us to think about it for when we're doing the education campaign and for the policy document which will accompany the bill. Who is going to pay for the counseling? Who will cover that cost? Is it on the public's purse? Is it Ms. Chin who has the wholesale where Marcia was harassed? Or was it Trevor who harassed her at the wholesale? And I want us to think about it because we have to have a plan for it. One of the shortages we have in Jamaica at this time is for mental health professionals. Where will we find these professionals for people to go to counseling, and who will fit the bill and where will they go? Because 1 hour with a counselor, a trained counselor, is between $5,000 and $7,000. So it's just for us to think through those dynamics, because if we put something in the bill that is not actionable, are we doing a disservice to the bill and to expectations?
Dr. Longmore, you should pay for that free advertisement.
I'm allowing the conversation to flow.
Senator Longmore, it's timely. I'd like you to, I know the SG wants to make a comment, and then Senator Longmore, I will invite you to make a comment after the SG.
Thank you, Chair.
Oh, well, just a quick one though, thank you, Chair, just to Senator Campbell Rodriguez, which very important issue raised, but don't you think it would be within the remit of the tribunal when making that award to also indicate, for instance, that the employer should foot that bill? Because I am thinking that it would be within the remit of the tribunal to consider saying the employee was victimized, we have that finding, we now direct that the employee should receive some counseling, and the direction could go further to say that it would be at the cost of the employer. And it could also even say something like, because when I look at the wording of how the awards can be made, it's wide. The wording is wide. So I understand the concern, but I think this is something that really could be addressed by the tribunal when they're making an award. I think it's just that maybe the tribunal will need some guidance, a lot of guidance. And that is what I was thinking through, how that will happen. But I do recall also, isn't there going to be a training component? So I don't know if maybe it's at that stage that that guidance can help. Plus, the tribunal will have to be making rules. And so perhaps even in these rules, they would be able to flesh some of these matters out. In fact, they will have to, because the rules will have to set out in a lot more detail the kinds of awards and how they make those awards. So for instance, with other tribunals, when they can award costs, those things are actually set out in their rules. Because if they're not really set out in their rules, then it's, remember that these bodies are all creatures of statute. So they can't operate in a vacuum. So I'm thinking that it can be addressed that way, but it's just that you're right, it won't be here in this bill. And I think these are issues that will need to be discussed further, especially when they are being established, meaning the tribunal.
Yeah. Thank you, SG. I don't know if Mrs. Coburn Robinson would wish to make a comment at this point. Mrs. Robinson? While I'm waiting on Mrs. Robinson, I think maybe Mrs. Seeley Brown. Mrs. Robinson, go ahead.
So, Minister, I do not wish to make a comment. No, I will be guided by the legal team.
All right, Senator Long. Yeah, go ahead. Yeah. All right. Thank you, Mrs. Robinson. Senator Longmore.
Yes, Chair. Thank you. I am happy to see the endorsement for the inclusion of this type of treatment. To answer Senator Campbell Rodriguez's concern, I think it was Mrs. Seeley Brown pointed out that as we award financial fees and financial consequences to the offenders, I think likewise the bill for this therapy would be so included and can be so included. Without a doubt, it is almost futile to have this process and not have a therapeutic arm to it, and an actively therapeutic arm, because the circumstances are such where even with the punishment that is given by the law, the persons tend to be predisposed to what we call recidivism, which is basically repeating and the offense. So what works is the therapeutic intervention that you guys have included. So by all means, I think it needs to be included and it can be provided for. Thank you.
Thank you, Senator Longmore. I'm going to ask Ms. Grant to just summarize or to just indicate what she has captured for more discussions here.
Okay, so thank you, Chair. So am I to understand that Mrs. Seeley Brown, going back to what he had said about I looked back in my notes and I found this thing too about the psychosocial support for those services to be included, specific proposals to be included in the legislation. But am I to understand, based on what conversation that has gone on so far, that we're saying that this should also apply to the perpetrator? Because initially I came away with the impression that these services would be available for the complainant and not the perpetrator. So I just want to make sure I capture the essence of the conversation, that these psychosocial services will also be open to the perpetrator accessing.
Well, through you, Chair, that's the note that I have. That
Okay.
it should not only apply to the complainant, but also to the perpetrator. I don't know if that's what is going to be agreed upon by the committee now, but that's the note that I have.
Thank you, Mrs. Celia Brown. Thank you, Ms. Grant. Can I have the committee agree that this will be so?
Most definitely, yes, Chair.
Okay.
Yes, Chair.
So we all say?
Definitely.
Absolutely.
Yep.
Yes, definitely.
Okay, so disclosure of matters in the public domain. Now, the committee noted the observation of the Ministry of Labor and Social Security that the bill does not expressly seek to cover disclosure made in the public domain. Neither does it state how disclosure of matters before the tribunal under consideration would be treated. The committee did not reach a decision on this. Ms. Grant, you may want to just expand a little on the discussion that took place in relation to disclosure and if it is provided for elsewhere in the legislation.
Okay, thank you, Chair. So the concern of the Ministry of Labor and Social Security was that there is no express provision in the bill to address matters that are currently before the tribunal. Well, let me rephrase it, that there's no provision in the bill that outlines how one should treat with matters that are already before the tribunal, and as such should not have any dialogue on those matters in the public space. So they're saying it is not expressly provided for as to, so we know that when a matter is before the court, for example, it's under consideration by the court, that there are no discussions, you have no discussions about the matter because it is before the court. And you know, the attorneys know the Latin for that. So they're saying there's no express provision there. I was looking through the bill and I was wondering, and my colleagues can correct me if I'm wrong, if the provisions in 33(1)(c) that deals with no particulars of complaint shall be published without the prior written approval of the tribunal. And I think there may be two other comparable sections that deal with or impose a duty not to communicate or divulge particulars of a complaint made to the tribunal without the tribunal's written approval. I'm wondering if those sections would not cover that concern.
Through you, Chair, I'm thinking that clause 33 does do the, perform that function because it speaks about the identity and the name and the address of the person being protected, and the fact that the information provided to the tribunal shall be kept confidential and shall not be published without the prior approval of the tribunal. So I think that provision is wide enough to cover the concern that was raised here.
And what if it's disclosed?
It's in contravention. Let's see. Let me see, Chair. Let me check and see if it's the offense is covered, Chair. Yes. Well, it doesn't. Yes. If you look at clause 37(4)(c), which speaks to contravention of section 33, where we have the fine as not exceeding. I think you had lessened it to not exceeding 500,000, or in default of payment, total not exceeding 3 months, Chair.
No, C is 1 million or 12.
Didn't we change it to 500? Wasn't there a proposal? My note has a proposal to change it to 500,000. I'm not wrong.
No, my notes have 37 for AB for 500 and 37 for CD and E for 1 million.
Okay, I stand corrected. But it is covered, Chair. It's a criminal offense if you contravene any of the provisions of clause 33(1), Chair.
Okay, yes. Okay, so what is the decision of the committee that it is already covered?
Yes, Minister.
Okay, fine. All right. Now the technical team was to look at a regime for compensation, section 34B2. 34B2. Ms. Grant, you want to please expand?
I think the concern at the time it was raised, Minister, was that because of how widely drafted it is, a direction that respondents should perform any reasonable act or course of conduct to redress any loss or damage suffered by the complainant, that we should come up with some regime indicating how this would be done. Chair, well, speaking for me, I know that it is certainly something that I would need more time to look on to come back to. If it's even something that needs to, that I would need to come back on, but I certainly would need more time to sit with this.
Okay, thank you. Any other comments? Well, members, we had agreed that we would go 11 to 3. It's now 3 minutes after 3. We have made decisions on a number of outstanding matters. We have a draft report. We also have a deadline with which we have to meet in completing our report. Since we had agreed that we would end at 3 o'clock, what I'm going to do is ask members to please go through this draft report. I will ask also Mrs. McCarthy to update the draft report to the best of your ability in the shortest possible time, and have an updated version of the draft report sent to members, who I'm asking for you to go through the draft report prior to the next meeting. I would like us at the next meeting to spend all the time that's necessary to finalize the report, so that we can in fact table that report as soon as possible. Which means that our next meeting, we would try to finalize that document. I know the technical team, they have a number of other matters to address, but we're asking you that those areas that we have asked you to come back to us on, if you could provide us with your feedback so we can make a decision one way or the other. I know the board, the matter of the board issue is a tough one, but please come back to us with some guidance and details as to the way forward. I want to ask if there are members who would wish to make a comment at this point before we wrap. You could do so. Or all members are satisfied that we have.
I would just like to be aware of the date of the next meeting.
Okay. Ms. McCarthy, you can guide us. We want to have the next meeting as soon as possible.
Well, currently, members, next week is completely booked unless we are going to double schedule for Tuesday at 10, which would be a challenge, possibly for members who are members of the PAC committee, which is scheduled for Tuesday at 10. Tuesday and Wednesdays in the afternoon is gone. The morning for Wednesday is gone as well. There are two meetings being held simultaneously on Wednesday. Thursday there's a meeting in the morning, and I'm the committee clerk for that meeting, and there's one at 2. I'm not sure. I would have to double check membership for the meeting at 2, and I think Senator Campbell Rodriguez is a member of that 2 o'clock meeting for Thursday. So already I'm seeing a double booking in terms of membership. So I'm not certain if there'll be anything else, Minister, if there's any change for next week, but I'm not sure yet.
We have to find time for next week. We're gonna have to figure it out. So maybe we can have further discussions, Ms. Mack, and see how we can negotiate some time and advise our members. But
Okay,
it is critical that we meet next week.
Okay.
Extremely critical. And we certainly would advise members as soon as possible. So let us see how we can find some time. And how soon you can send the updated report so that when we meet, we would have gone through the report so we can move through quickly in maybe a short window of time that we would have been able to negotiate.
So it wouldn't require an extensive meeting then, Chair?
It would require an extensive meeting.
It wouldn't or would?
It would require an extensive meeting, but we may have a narrow window to have that meeting. So it would require for you to really read this report and go to this report, the updated report, prior to us meeting.
Agreed on that.
Okay. Yes, SG, please make your comment.
Thank you, Chair. Just asking if the revised report could be done in a way like track changes, because I've already started going through. It would be easier to see what is being changed, and just to also just indicate that there are members of the technical team who are also on these other committees. So it's not just the members, so we'd have to also be careful about that, because some of us can't, it's not possible to monitor both committees at the same time. Just pointing out that when it's that discussion was only in relation to the members, but not in relation to the technical team who are also
sorry.
Yeah. SG, I always bear in mind the technical team when I speak. And I know that you
I know, Chair. I know. It's just that, so for instance, like that Thursday, the joint select, if there's another joint select, it may be a little challenging. So the reason I was going here, because, you know, there are times I've seen it before where the chair of one committee has a discussion with the chair of another committee to see if one could give way to another, especially when there is a urgent situation. And for instance, now you're trying to wrap up and there are others that are sort of still in infancy stages. So rather than stress out a lot of people about the doubling up, if, for instance, a discussion could be had at a certain level.
Yes.
That's where I was kind of going.
Yes, SG, I intend to do that because this piece of legislation has to be, I have some deadlines to meet in relation to this piece of legislation and as it relates to other matters. So,
I'm in agreement with that approach, Chair.
yes. So I will have discussions. Ms. McCarthy, just guide me as to with whom I should have those discussions.
I'm sorry, Chair, I got distracted. Could you just repeat the question? I'm sorry.
I just ask you to guide me with whom I should have those discussions where we can negotiate, where priority would be given to this meeting, to this Joint Select Committee meeting, as opposed to another Joint Select Committee that does not have as short a time period within which to conclude its work.
So you're substituting it with one next week.
Yes.
You're just asking to crave the indulgence of another committee next week so that we can use the time because of where we are now and we wanting to conclude.
Yes. So if you guide me, we can do that off the air.
Yes, Minister.
And then we can advise our members.
Okay.
Okay?
Okay, Minister.
All right. I just want to thank members that you have been just fantastic. That's fantastic. And I think this piece of legislation will be far-reaching and impactful. Just want to thank all of you, members and the technical team and the staff for doing such a wonderful job. And of course, for PBCJ, giving us the coverage and the exposure that's required. I get calls from all over the world, and persons are commending the work of this team. And I just want to thank you so much. So with those words, I wish to now adjourn the meeting and to say thank you to everyone. Be safe.
Thank you too, Chair.
Thank you.
Good.
Have a good weekend.
Thank you, Chair.
Thanks,
Take care,
colleagues.
everybody.
Take care.
Keep safe all, keep safe. Bye.
Jamaica is a beautiful place. Our people have a beautiful spirit, but we are too aggressive, and the way we interact with our friends and neighbors, I genuinely believe that we have the capacity to deal with this problem of violence. But it's going to take all of us. It's going to take every organized group of Jamaicans that we fundamentally reject violence. Violence has no place in a modern society.